Mohon izin, saya di sini akan memulai acara International Conference on National Conference. Bismillahirrahmanirrahim. Namo Buddhaya, Om Swastiastu, Shalom, Assalamualaikum warahmatullahi wabarakatuh. Good morning. To the Honorable Rektor of Universitas Pembangunan Nasional Veteran Jakarta, Dr. Erna Hernawati, Dean of Faculty of Law, Universitas Pembangunan Nasional Veteran Jakarta, Dr. Haji Abdul Halim, Chief Justice of Supreme Court of Indonesia, Yang Mulia Dr. Haji Muhammad Syarifuddin, the speakers of International Conference on Law Studies, Profesor Hikmahanto Juwana, Rektor of Universitas Jenderal Ahmad Yani Indonesia, Profesor Arya Nafisa, Assistant Professor at Washington University in St. Louis, Mr. Norris H.C. Yang, Director of ABR International Limited Yang, Chen and Jamison LLP, Hong Kong, Professor Dr. Hartini Saripan, Dean of Faculty of Law, University Teknologi Mara, Malaysia, Kamilah Kasim, lawyer of Allen and Gladhill Law Firm, Singapore, and to all participants of International Conference on Law Studies. It is truly an honor for all of us to gather on this wonderful occasion, and I would like to thank God for giving us mercy and blessings so that all of us can meet and help the first ever International Conference on Law Studies. This event is held by Faculty of Law, Universitas Pembangunan Nasional Veteran Jakarta, with the main theme, Law Policy on Transnational Issues. We hope that this conference and discussion panel can provide all of you with information related to policies and legal provisions on cross-border issues. My name is Kaila Raisa Fitri as the MC for today's conference, and I will be reading the time schedule for today. 1. Opening, which consists of singing Indonesian National Anthem and Mars Bela Negara. 2. Welcome speech by Rektor of Universitas Pembangunan Nasional Veteran Jakarta. 3. Keynote speech. 4. Discussion panel along with Q&A session. 5. Closing speech by Dean of Law Faculty, Universitas Pembangunan Nasional Veteran Jakarta. 6. Closing event. As our first agenda, which are singing Indonesian National Anthem, Indonesia Raya, and Mars Bela Negara, we would like to ask the audience to stand. Thank you, ladies and gentlemen. You may sit again. Our next agenda is welcome speech, which will be delivered by Rektor of Universitas Pembangunan Nasional Veteran Jakarta. We would like to welcome with honor Dr. Erna Hernawati. The time is yours.
Thank you, Kaila. The Honorable Dr. Haji Muhammad Sarifuddin, SHMH, as Ketua Mahkamah Agung RI. The speakers, Profesor Dr. Hikmahanto Yuwana, SHLLM, Mr. Norris Echi Yang, and Associate Professor Dr. Hartini Saripan, as Dean of Faculty of Law, UITM, Dr. Ariana Kisa from Washington University, Mrs. Kamilah Kasim from lawyer of Allen and Firm, Glady Law Firm, Singapore, and my colleague Dr. Abdul Halim as a Dean of Faculty Law Science of UPN Veteran Jakarta, and all staff and all participants. Ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh. Good morning all. Praise be to Allah Subhanahu wa Ta'ala, Almighty God, for His grace that today we can still gather in this event, even though we still in COVID-19 pandemic. Hopefully this condition will soon be better and we can live normally again. Amin, amin ya rabbal alamin. This event became very useful, I think, with the presence of the all excellent speakers. And thanks for the opportunity and time to share. Big thanks also to the Dean, Dr. Abdul Halim and his staff, who are still enthusiastic to do something valuable during this pandemic. This is, of course, in line with our commitment that in COVID-19 must not be a barrier for us to remain productive. All academic activities must not stop it. Lecture activities and examination, webinar service continue to run as usual, with maximum effort by staying obedient with recommended health protocol. Ladies and gentlemen, the objective of higher education, few of many, is to develop and to share knowledge, technology, and also to optimize the society quality and to preserve national culture. Those objectives, I think, are achieved through research and social contribution. This is the main idea behind INCOLS, or International Conference on Law Studies, which was initiated by Faculty of Law UPN Veteran Jakarta. Therefore, I deeply appreciate it to all parties who participated in this event, the guests, speakers, and Dean of Faculty of Law and the team who has done an excellent job to consistently conducting an annual international seminar in this year. I would like to also express my gratitude to all participants who have contributed this event through their paper submission to share the insight of their research. Today's discussion will focus on very interesting topic because it is related to the issue about laws and policy of transboundary. University as a part of higher education are encouraged to provide any valuable insight that will be useful in providing alternative or even solution to such complicated problem. Therefore, my expectation for all the research that had been submitted is it not for to be stopped here in this conference or just publication platform, but rather for it to be further continued so it can give actual benefit to the society. As that is one of the main reasons why we all are here in this event. Hopefully, through this event, applicably, insight is gained, not just for our personal knowledge enhancement or for activity report, but also to provide alternatives that are impactful to all stakeholders involved. Last but not least, thank you and appreciation to Associate Professor Dr. Hartini Saripan as a Dean of Faculty of Law UITM. Hopefully, this collaboration between UITM and UPN Veteran Jakarta will continue to prepare the next event. I also hope that all of you had a great time in this conference and gain a lot of original and innovative ideas as well. See you later in another occasion, or maybe in the second INCOLS in 2022, inshallah. Finally, by saying Bismillahirrahmanirrahim, herewith this event, I declare it start. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Salam bela negara.
Salam bela negara. Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Dr. Erna Hanawati, for the wonderful welcome speech. Ladies and gentlemen, now it is time for us to hear the keynote speech from the honorable keynote speaker for today's conference, Chief Justice of Supreme Court of Indonesia, Yang Mulia Dr. Haji Muhammad Syarifuddin. The time is yours. To the Chief Justice of Supreme Court, is my voice clear? Ada Mahkamah Agung, apa sudah terdengar suara saya untuk bisa memulai keynote speech di event pada hari ini?
Kayla?
Iya.
Okay.
Oh iya, selamat datang Pak Imam.
Yeah. Within 3 minutes, within 3 minutes, Chief of Justice will come down to the Zoom, ya. 3 minutes, ya. Just come down.
Okay, in 3 minutes. Okay.
Conference room, ya. Thank you.
Okay.
Kayla? Nanti
Yes, sir.
kalau beliau datang kembali lagi diulang di welcome, sambut lagi beliau ya, sambut lagi sebelum dia masuk ke Zoom ya. Oke. Thank you. Kayla, please again welcome. Kayla, yes.
Okay, I would like to reread once again. As our next event, which is it is time for us to hear the keynote speech from our honorable keynote speaker for today's conference, Chief Justice of Supreme Court of Indonesia, Yang Mulia Dr. Haji Muhammad Syarifuddin. The time is yours.
Honorable Chancellor of the Transnational Development University, honorable guests, distinguished speakers and participants, ladies and gentlemen. Praise and gratitude, let us extend it to Allah Subhanahu wa Ta'ala, God Almighty, because with His grace, this morning we can meet virtually in a series of activities of the International Conference on Law Studies. First of all, I would like to express that I am honored to receive an invitation from the Faculty of Law of the Transnational Development University to give a keynote speech at this international conference. The Supreme Court views the importance of the entire series of activities of this international conference as a forum to meet and share experiences related to policy and legal provisions and transnational issues. The Supreme Court also views the importance of this activity as a forum for meetings and exchange of information between experts and researchers. As a means of socialization in dealing with transnational issues and developing research network and other collaboration in the legal field. Honorable conference participants, we need to discuss law and policy in dealing with various transnational challenges, including the first is the challenge of economic cooperation during a pandemic situation. We need to discuss policy that can improve market access, protect and secure national interests. It is also important to discuss legal instruments for trade cooperation through international trade agreements. The second is the challenge of transnational cybercrime. We need to discuss policy for effective prevention programs, technique of investigation and prosecution, and case handling. Protection of victims and management of rehabilitation of offenders. It is also important to discuss the legal rule regarding data protection. For example, in Indonesia, we can find in consumer protection law, electronic information and transaction law, government regulation concerning implementation of electronic system and transaction. Ministry of Information Regulation concerning protection of personal data in electronic system. The third is the challenge of human resource cooperation. We need to discuss human resources cooperation among law enforcement officials. We can examine an example of capacity building for transnational cooperation in dealing with cybercrime is Project Cyber East, which is a joint project of the European Union and the Council of Europe, implemented in the Eastern Partnership area by the European Council under the European Neighborhood East Instrument. The project aims to adopt a legislative and policy framework in line with the Budapest Convention on Cybercrime and related instruments, strengthen the capacity of judicial and law enforcement authorities and interagency cooperation, and promote efficient international cooperation and trust in criminal justice, cybercrime, and electronic evidence between service providers and law enforcement. Finally, the transnational environmental challenge, we need to discuss policy to facilitate environmental dispute resolution. For example, in Indonesia, since 2013, the Supreme Court of the Republic of Indonesia has issued a Supreme Court decree on guidelines for handling environmental cases. In 2014, the Ministry of Environment issued a regulation to facilitate the settlement of environmental disputes. Honorable conference participants, with my pleasure, I would like to take this opportunity to convey that the Supreme Court has implemented and started important steps to fulfill the principle of simple, fast, and low-cost judiciary. Since 2018, the Supreme Court of the Republic of Indonesia has launched the electronic code application after previously using regulation concerning the implementation of electronic cases in code as the legal basis for its implementation. The purpose of making this e-code is to facilitate justice seekers in solving civil cases in the General Code, Religious Code, and State Administrative Code. After a year, e-code has now been evolved into electronic litigation through using Supreme Court regulation. Previously, e-code only facilitated 3 types of electronic-based services, e-filing, e-payment, and e-summon. Meanwhile, e-litigation allows sending answer, replies, responses, evidence, and assessment to be done electronically. In 2020, the Supreme Court of the Republic of Indonesia has issued a Supreme Court regulation concerning the administration and proceeding of criminal cases in electronic code. The application of e-litigation has significantly enhanced the presentation of Indonesian justice toward a modern justice based on information technology and is anticipated to facilitate the resolution of transnational issues. Honorable conference participants, in closing, I would like to thank the organizer of the series of activities of the International Conference on Law Study today, especially to the Faculty of Law, Petra National Development University, Jakarta. To all conference participants, I would like to congratulate on sharing experiences related to policies and legal provision on transnational issues. We are looking forward for a sound recommendation that can be taken into consideration by the Supreme Court and related agencies. Thank you very much.
You're welcome.
Thank you very much, Yang Mulia Dr. Haji Muhammad Syarifuddin, for the wonderful and informative speech. Ladies and gentlemen, before we continue to the main agenda, we will give a 5-minute short break to the participants starting now.
Kayla, excuse me, Kayla, udah pergi ya. Thank you very much. Okay.
Once again, I will talk in Indonesia. Terima kasih banyak kepada Yang Mulia Dr. Haji Muhammad Syarifuddin atas pidatonya yang sangat informatif, dan saya selaku perwakilan dari panitia juga ingin mengucapkan mohon maaf apabila terdapat kesalahan, dan kami mempersilahkan kepada Yang Mulia untuk meninggalkan ruangan apabila memang masih terdapat kepentingan di waktu selanjutnya. For now, we are still having a short break for the participants, and we will continue shortly. Thank you.
MC suaranya nggak itu. Nyalain dulu itunya. Nggak kedengaran suaranya, masih mati itunya mic-nya. Mbak Kayla.
Kita untuk sekarang sedang istirahat sebentar, dan kami mempersilahkan kepada Bapak Yang Mulia untuk meninggalkan ruangan apabila masih terdapat kepentingan yang lain.
Kan? Tolong di print ini kan.
Welcome back, ladies and gentlemen. Now, coming to our main agenda, which is discussion panel with our wonderful speakers, moderated by Dr. Imam Haryanto, SHMH. We would like to welcome every speaker, and we also would like to welcome Dr. Imam Haryanto to guide the panel. The time is yours.
Okay, thank you very much, Kayla, the MC. First of all, I would like to say thank you very much for our rector, Ibu Erna Hanawati, for the make opening speech today, and then also the key speech from High Supreme Court, Chief of Justice, Yang Mulia Bapak Dr. Haji Muhammad Syarifuddin. And we would like to have a discuss today, probably until 12 o'clock. And then we are very happy today. We have combinations between the speaker of practice and also the academic scholar. Yeah. And then I would like to introduce one by one. First speaker, Associate Professor Arya Nakisa, and then also Mr. Norris Yang, BSc LLB. And the next speaker also Associate Professor Hartini Saripan, Dean of Faculty of Law UITM, Institute Teknologi Mara. And then also Ms. Kamila Kasim, LLB LLM, as a practice of partner Alan Gladhill Law Firm in Singapore. And then the last speaker is Professor Hikmahanto Juwana. Yeah. So because of the time is very tight, and then we allow them to speak one by one and then continue by question. And then probably they can leave the room. And after that, I'll ask you, if you have any questions, please you can type on the chat room. And then you can also, if you have to have any direct questions, you can raise your hand or mention your idea or question, and if you want to like to directly speak, we can allow you also. Okay, not in further delay, I would like to call the first speaker. Today is Mr. Associate Professor Arya Nakisa. Are you already joined this meeting? Associate Professor Arya Nakisa from Washington DC. Not yet? Hello? So, sorry, if not him already available, can I call Mr. Norris Yang from Hong Kong? Are you already joined for this conference?
Yes, I am.
Excellent.
Can you hear me?
Okay. Hey, thank you, sir. I hear you.
Okay.
So, first of all, before you speak, allow me to read your brief curriculum vitae. Yeah. Actually, Norris Yang is my old friend. Yeah. Norris H.C. Yang is study in University of Toronto for Bachelor of Science with honors, yeah, 1974, and also got LLB 1978 from University of Windsor. He also now a fellow of Chartered Institute Arbitrators, FCRB 2008, and he also registered as mediator in Hong Kong and Hong Kong Mediation Center, also in China. And actually he's a lot of recognized who legals, especially for the thought leaders for mediations since inauguration year 2017, 18, 19, and 20. Actually, Mr. Yang is a leading international commercial mediators in 2020. Annually, since this list was established in 2011. Now, Mr. Yang also as a executive director of ADR International Limited, and also working at Yang, Chan, and Jamison LLP solicitor. Yeah, so we are very happy to have him today, and he would like to share his experience regarding about the His topic today is mediations as effective dispute resolution strategy for international business disputes. So, not in further delay, we welcome Mr. Norris Yang. Please, now your turn, sir.
Thank you very much, Dr. Haryanto. It's good to see you again, and I'm glad to visit Jakarta via Zoom, even though I cannot fly. Of course, my many thanks to Dr. Emma Hernawati, and to hear that the Chief Justice of the Supreme Court of Indonesia, Dr. Muhammad Sarifandin, also speaking. And it is a great honor for me to be here today. And so I will start off with one word I learned is Salam Alaikum to everyone.
Salam.
From Hong Kong. It's not a very, it's a little bit cloudy, but as long as we are all very happy and sunny in our inner spirits, then we are fine. Okay, so I would like to share my PowerPoint. So I'm not very good with technical, so please bear with me for a while. And I will get it done. So, can we see the slideshow?
Not yet.
Not yet. So let me, okay.
Yes, done. Yes, you got it. You got it, sir.
You got it. Okay,
Yeah.
Fantastic, fantastic. So it's a very long topic today. Mediation as effective dispute resolution strategy for international business dispute. But really, it's quite easy because mediation actually works for many, many different disputes. So let's go to the next slide. Let me share with you what we're going to discuss for the next few minutes. And for some reason, it is not going to the next page. Let me see how we should do this. Ah, there it is. So, first of all, we'll talk about what people involved in international business disputes want to have. So it's their wish list. We'll talk about the definition of mediation, the role of the mediator, and then we'll talk about something which I call INCs. It's not incorporated as a limited company, but interests, needs, and concerns. And we'll talk about why negotiations or mediations fail. These are certain factors which make them very unsuccessful. And then we'll talk about the mediation procedural pyramid, which is how we conduct a mediation. And then lastly, factors why negotiations or mediations will succeed. And then we can see how that wish list works. So first of all, let's look at the wish list, and it's not going to the next page. Now, how should I do this? Ah, there it is. Wish list. So, wish list. What do you want to see? They want it to be fast and effective. And they want a procedure that's fair and easy to understand. They want to be dealing with professionals. They want an enforceable settlement agreement, of course, time and cost efficient. Who wants to spend a lot of time and a lot of money for getting to a dispute, resolving, and seeing that you can stop any litigation or arbitration? So, of course, if you look at how this company is doing it, it says, I don't get it. After all the budget cuts to streamline the workforce, why aren't we moving faster? So what they've done is all the big executives are staying on top, and there's only one person who is rowing the boat. Of course, that's not effective. So we don't want to have this. We want to have a good resolution of our results. So Now, we are going to go through the definition of mediation. And this is it. So what is the definition? It seems to be a very, very long definition, but really, let's go and define this. It is actually a dispute resolution process. So mediation is a process. And what kind of process is it? It is a voluntary dispute resolution process. It is a non-binding dispute resolution process. It is a private dispute resolution process. And in this process, there's a neutral person called the mediator, and he's the person who tries to help the parties to reach an agreement, okay? So notice he's helping the parties. He's not making the decision. He's not saying who's right or wrong. He's not saying who will win or lose, but he's helping them. Sometimes we use the word facilitate. But helps is good because it reduces the words on the PowerPoint, and then we don't have such a long slide. So it is the mediator who helps the party reach an agreement. What kind of agreement is it? It's a settlement agreement. It's a negotiated settlement agreement, and it is their own negotiated settlement agreement, which means that it is the parties who come up with the agreement and the settlement terms. So, what's the role of the mediator? Okay, here he is. If you look at this slide, you see if all the lawyers are involved in mediation. Here's the lawyer at the left-hand side, and he's the mediator. And he says, see, if you stick to it long enough, you will come up with an equitable deal. And look at the participants, their knives all over the place, their knives in the back, knives on the table, and maybe they're even dead, who knows. So that's not the way we want to do it. We want to do it in a way where people are happy at the end, and they have a solution which they can work with and they can implement and execute. So we have a neutral mediator, and remember we use the word help or facilitate. And then he uses a collaborative approach. What that means is he wants the two parties to work together. And then he or she, the mediator, is helping the two parties to work together. So it's actually a collaborative approach of the parties and the mediators working all together. And what do? They negotiate. So the mediator helps them to negotiate a mutually agreed settlement agreement. Now, a lot of people ask, he says, well, you know, I see a case and I know from the case and the facts what the solution should be. Well, guess what? In my books, the parties, they have been arguing for months or years or decades. And how can we, by just looking at silly documents, can come up with a solution for them? That's a bit too much. At least I know I cannot do it. And that's why we need to go through the mediation and understand from the parties what exactly is bothering them and how we can deal with their case. So we go along, and then we talk about something called interests, needs, and concerns. Now, the role of the mediator is successful, most successful if there are 9 elements present, and we call it NEGOTIATE, and I will introduce that just a little bit later on. So, interests, needs, and concerns. Now, when a person has a position and he says, let's say, very simply, I want to eat laksa today at the Tasty restaurant. So that's his position. So if somebody asks me, what do you want to eat today? I said, I want to eat laksa today at the Tasty restaurant. So I want it. So it's my wish list, it's my outcome, it's my solution. This is what I want. And the position is what we call narrowly framed. It's I want to go to the laksa at Tasty restaurant. And I've told you what my position is. But what is the position? Where does it come from? Actually, a position comes from what the party wants. Okay, let's go to the next slide, trying to do that. Okay, I have a dispute with my computer. Okay, so what it is the position is based on the interest. So the interest is really why the party wants to have the position. So there are different motivational factors. We have to analyze each person's real understanding. You know, when you go into a negotiation, or even when you talk to your friends and colleagues or your spouse or your loved ones, you don't really tell everything from your heart. There are things that you hold back. This is quite normal. And certainly in a litigation or an arbitration or a dispute, you do not want the other side to know what's really on your side, okay? What's really in your mind. So if we use interests to understand what is going on, we're trying to get all sides as joint problem solvers, not opponents. And we want to understand what our mutual interests are and try and create options and focus on what we want, and then try and find one or more solutions or options. So remember I said I want to eat laksa at the tasty restaurant. What do I mean? So let's go to the interests. Interests, there are actually three kinds of interests. One is called procedural interest, which is sort of like a how question. And it's how the dispute is managed, how the settlement is implemented. And there are what we call process interests. So what are procedural interests? Who talks first? Who talks longer? Can I have 50 minutes and you only have 5 minutes? Can I shout at you and you have to stay very quiet? So these are procedural interests. Do I have equal time with you? Number two, psychological why questions. They're emotional, spiritual, and mental needs. So it could be that I'm telling you to meet and in, let's say, in London, and I tell you it's casual, and I turn up in a suit, and everyone turns up in a suit, and you're in a casual mode. So it changes your thinking. Or you go to a mediation or negotiation, and you say to the other side, well, we just have a quick drink or coffee somewhere. And I show up with 15 people and you come up by yourself. So these are psychological problems that will affect the whole negotiation. And the third interest would be substantive. It's a what question. It's material needs, things you can count. It could be money, it could be number of widgets. It could be, can I have 2 bowls of laksa instead of 1 bowl of laksa? So interests are like this. So you have your position, and underneath that you have interests, needs, and concerns. So we talked about the different interests, and so which was the procedural, psychological, and substantive. Now, if we put those 2 triangles together and you have a position, this is what I want, this is my disclosure, this is my objective, but really deep down, there are underlying reasons and interests. And those are represented in this double triangle. And you notice that there seems to be a bit of water underneath that position. I want what I want, laksa at tasty restaurant. So why do I want laksa at tasty restaurant? It could be that I had wonderful laksa just yesterday and I want to retaste the laksa again. And why do I want it at tasty restaurant? Well, it could be I have a coupon for a sale, or maybe it's very close to where I'm working, or maybe I'm supposed to have dinner with my mother tonight, but I can't because I made an agreement with you to have dinner with you or the whole group. So if we go to tasty restaurant, my mother will be there, the group dinner will be there, then I can sort of do 2 things at one time. So these are interests which I may not tell you. I may not tell you I want to eat laksa at tasty restaurant because my mother blah, 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 blah. It's too long. I'll just say I want to eat laksa at the tasty restaurant. Or who knows, maybe the last time I was at the restaurant, there was a very, very pretty waitress there, and I want to see her again. Who knows? So the position that I want, which is to eat laksa at the tasty restaurant, is based on interests which I have not disclosed. So in a mediation, what we want to do is trying to get people to explain why they want certain things. Now, if you look at this little ripple just underneath disclosure of positions and interests, you'll see that it kind of looks like an iceberg. And indeed it is. What is on top is all the stuff that you hear about in a litigation, all the pleadings, all the wordings and the affidavits are there. But underneath are the real reasons why you are saying certain things, or why you want to sue this person, or why you want to defend your case. So what we need to do is try and find out more about what's underneath the water. And it is really important because 90% of an iceberg is underneath the water. And if you don't believe me, please, I doubt you can do it, but if you can, talk to the captain of the Titanic, and he will tell you that what is below the water is really, really important. So now let's come to factors why a negotiation or mediation might fail. Okay. Lack of trust, no sincerity. I don't trust you. Guess what? That's what we do because this is what we deal with oh dear, I have a slight problem with my computer. Okay, it's okay. So there's no sincerity. We really don't want to negotiate. Second one, there's no communication. We don't talk to each other. How can you negotiate when you don't talk? And we've seen that with our parents maybe when we were younger. They don't talk, and then there's no communication. And then sometimes we don't exactly tell the truth. So there's misrepresentation. Or sometimes there are hardball tactics. And that's not very good either. And sometimes we're stuck in the past. It's like, you were always late. You have never been on time. You have never delivered your proposal. You have not executed what you promised. So people are stuck in the past. They don't want to go to the future. Or I am more important than you are, so you must listen to me, or you must do what I tell you. And this happens a lot when you're dealing with people who have power, okay, or used to having power. Now, so in these situations, you know, sometimes we need to be a little bit more realistic. The Viking is telling the other guy, he says, I got it too, Omer, a strange feeling, just been going in circles. And of course, they're not really realistic, because on one side, there's these great big guys who are rowing, and the other side, it's this small guys like me who's rowing. And of course, there's only 3 of them versus 4 of the big guys. Of course, it is going to go in circles. So let's go. Some more. No agreed rules for negotiation. This happens all the time. When you go to a meeting, you need an agenda. Now, if you don't have an agenda, or you negotiate and you don't know who's going to say what or what's going to be on the topic, it goes all over the place, okay? So you don't want that. So the discussions were unfair, or there are terms where it's not very favorable to you, and you say, okay, it's one side is negotiating in the morning, and somehow the other party is negotiating at night, in the middle of the night. Well, it's kind of tough when you're negotiating at night. So sometimes people will try and do that. And then we have a positional view, a competitive view. I'm right, I'm fair, I'm logical. It's a win-lose scenario. And what I want is right, because I am right. So you must listen to me. And what I tell you is the law. Now, this is very clear. When people have a different direction, then negotiations fail. So these people in the car are having what they call a camera safari with the bears, but the other bear who's letting the air out of their tires maybe have a different objective. So that's very difficult to negotiate whatever you want. Okay, so next one. And now we have the procedural pyramid. Now, this procedural pyramid is a a different visualization of what I view as a good mediation process. Now, let me talk about the mediation process. It's actually the mediator's job to use the mediation process and the collaborative negotiations to help with getting a result. And the process defines the boundaries where people are going to negotiate. So you don't want to negotiate here, there, and the other. So it's too much. So what you want to do is you want to reduce some of the parameters so that it's a little bit smaller, and we can focus on certain things, and we can hopefully change the usual thinking of distributed negotiations into an interest-based negotiation. Okay, so the mediator reminds the parties of the boundaries where they should be. So he's sort of like a referee, but he doesn't give advice or judgment. So the mediator is in charge of the process, but not in charge of what is being said, because people should express their views, and he's not in charge of how they should think or what the settlement procedure should be. And he facilitates the parties to their own negotiated settlement agreement. And in the mediation process, you will note that when the parties appoint a mediator, they're actually agreeing to the process and procedures of mediation. And this is really important, because in my appointment, I tell them, you will be honest with your representations, you will work hard towards a settlement, and you will try your very best to work with the other side. So here's the pyramid. Now, I'm not going to talk about the pyramid in great detail, because this would be a one-day lecture. But what basically is at the bottom, you have the foundation for the pyramid, where you do a lot of case assessment and intake and a lot of preparation work. And then stage one is where you have information gathering, where you want to gather information from the parties. Stage two is when you have exploration of the information that you've gathered. And then stage three is when you start the negotiations. And this is only the time when you start having private sessions with the parties. And only then you go to stage four for the settlement. It is normal, and it's frequently seen that parties, solicitors, and young mediators want to go to stage four very quickly. They see and they gather some information. They don't explore it. They don't start negotiating, and they want to go to settlement. This is normal. Lawyers want to resolve things. This is our training. Whenever somebody asks us a question, we always have the answer. This is a problem for mediators when they have interaction with other people, because we are always giving advice, and sometimes we think we're always right. So what happens with the process is this, and I'll explain it a little bit. The process, the pyramid, it's structured, and each step builds a foundation for the next step. Okay, why is it a pyramid? Because you have to go up the pyramid, and it takes effort and time to go up step by step. So we must work hard towards the goal of settlement. We try and gather the information first, which is at the very bottom, the stage one. And we are trying to identify so those are the two stages, and then we go to the negotiation stage. And please do not negotiate before you explore or before you get all the information. Negotiate. Each step, you must prepare it well, and then, honestly, the settlement becomes easier. There are people who think that they can jump steps, and if you have ever climbed stairs, which I'm sure you have, it's easy to climb step by step. It's okay to go 2 steps at a time. I think I can do it. I can still do it. I'm sure many of you can do it. it's very difficult to go 3 steps at a time. And 4 steps, 5 steps, you should be jumping. And that becomes dangerous. So the whole concept of the pyramid is you must do it step by step. And of course, if you didn't do a proper step, then the next level you build will not be stable. And if your foundation is not well done, then of course the whole structure is not stable. So you want to have a stable step, then you build a new one. Of course, we can retrace steps. Sometimes we may not have done a good enough job, and we find out, this level could be redone. Let me do it again. And sometimes you can have several sets of private meetings, which we call caucuses. But please follow the process step by step, because if you follow the process, what will happen is, even if it seems very tough to get a settlement agreement, if the parties appreciate the process because they're now able to talk about their views, they're able to share the views with the other side, they're able to explore options because of the mediator's facilitation, then the chances of them going into a settlement is much higher. And the funny thing about a settlement is this: when you have 2 parties and they are at odds with each other, there's a huge gap between them. And what we try and do is, in the mediation, we want to get closer and closer together, get them closer and closer together until they finally agree. Now, how do they agree? Is the process sort of like slowly coming together and then they get to an agreement? Well, the real process is very interesting. When you have a big gap like this, right, you get closer, 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 closer together, and then suddenly, even though it's not very close, you have a settlement. So our job is to get a settlement. We don't know where that point is, where the parties are willing to go bang like this and settle. We don't know, but it will come. And as we go step by step, it will get easier and easier. Okay, so from the pyramid settlement, let's go into factors why negotiations or mediations succeed. And there are 9 of them. You see, the first one has a bold N. It's negotiation strategy for the future. So when we go into a negotiation, we must have a strategy for future and mutual gain. And the second one is E, effective interactive listening, open communication. We must listen to the other person. And guess what? We must listen to ourselves. And it's called interactive listening because it's not listening per se, but listening but interactive with both sides. So the other side understands that we understand. And we listen and we reframe and we have mutual communication. The third one is the G, go for fair negotiation process. So notice why we talked about the negotiation period. It's a fair process. Remember the interest, needs, and concerns. One of this is a procedural interest and a psychological interest. And these interests are things that we can more or less control with the process and allow the parties to go through a process which they accept. Then we try and have an O for options for mutual gain, and so that we can brainstorm and be open-minded to options. And then the fifth one is a T. We have to tackle the problem. Okay? A lot of times we hide in the problem, which is quite normal. We are ostriches. We don't want to deal with it. If I don't get up from bed tomorrow, after I sleep tonight, maybe the problem will go away. Or if I don't talk to them, maybe it will rain and therefore there's no meeting. So we need to separate the people from the problem, and we need to be soft on the people and focus on trying to get an agreement based on mutual needs. And then the sixth one is interest focus. We must look at interests of both sides and try and set aside our position and try and have a mutual understanding for each other. So now this guy is trying to find a solution. So he thinks he can run faster with a pair of running shoes, new pair of running shoes. Is he going to work? I don't know. Has he done any research on this? I don't know. Should he have bought two pairs of running shoes, one for the front legs and two for the, one pair for the front legs and one pair for the rear leg? I don't know. Maybe he runs on two legs. But it's an interesting cartoon because he is looking for options. Does it work? No, but try. His parents might not like it because he's not using his natural abilities. Okay. He thinks it works. So the seventh is an A for agenda, itemize and prioritize. We must have an agenda. We have to agree on the issues for discussion. The eighth one is T for trust. Very important to talk about trust. As long as one party is not interested in trust, it's not going to work. And 9, execute commitment of agreed term. It's no good agreeing on the term and then you don't implement. Let's say you go to a shop and you see something you really like, you have a bargaining session with the owner, and it goes from 500 rupees to 100 rupees, and you're all ready to give that 100 rupees to take out the money from your wallet, and the owner says, I'm not selling to you. Ooh, that's not very nice at all. So you don't want to see that in a negotiation. Now, something that you will realize, I hope, is that the parameters that I showed you about what are things that will make a mediation or negotiation unsuccessful is either one of those parameters will make it unsuccessful. So, for example, if somebody is really tough, hard for tactics, or they don't want to communicate, or there's no trust, or they don't want to tell you what's in their mind, then either one of these parameters will make that negotiation unsuccessful. The 9 parameters you see here, very funny. If you have one of these that are missing, it's tough to have a successful negotiation. So you must try and get all 9 of them together. And if you remember carefully, I mentioned to you NEGOTIATE. These are the 9 letters for the word negotiate. Okay, so I know we are running out of time, so you can look up the PowerPoint later on. I've allowed the organizers to share it with you if you want. And read that and you understand you need the 9 parameters to be successful. Okay, so these are the reasons and the parameters. So how are we working out? Well, you know, there's a very interesting thing that people think that all mothers are really good mediators. So here's the cartoon. The man says, you know, it hasn't worked. So I've just brought in everyone's mother. So hopefully that will work. So let's go back to the wish list. What was the first one? Fast and effective. Mediation works really well. It's fast and effective. I have conducted one of my most difficult mediation with a team of 3 mediators. It was a case litigated in 7 jurisdictions for 5 years. I have including all the parties, which total about 12 lawyers who were representing these clients from different jurisdictions. And one of the case was being dealt with in Toronto, and the judge reckoned it would take 100 file days in Toronto alone. So it didn't include Japan or China, Hong Kong, or London, or Guernsey. And so the judge knew that I spoke different dialects of Chinese. So we conducted the mediation in English because the legal counsel were all English speaking. The parties spoke Mandarin, Putonghua. Some parties spoke Shanghainese, some parties spoke Cantonese, and it was quite funny. We were doing this, and in 6 days we resolved it. And the 7th day was used to complete the settlement agreement where all the lawyers sat down and we hashed out the agreement. It was quite fast compared to what it would have taken just in Toronto, 100 hours. It's a fair procedure, and the procedure is easy to understand. Guess what? Mediation works really well. So dealing with professionals, of course, we've got trained mediators, and you're also dealing with your own lawyers, and of course, they're well-trained. Enforceable settlement agreement. Guess what? We have the Singapore Convention. So now we can have an effective way of implementing settlement through that convention, as long as more and more countries will sign up. Then we're missing the number 2. What is it? Time and cost efficient. Of course, mediation is time and cost efficient. So I hope I've proved my case that the wish list for business leaders to resolving disputes that they have all been identified and resolved with mediation. And this is what I hope is that people will use more mediation for resolving disputes. And even before that, I hope that when you write your contracts, you have a clause that says, let us mediate first before we go to arbitration or litigation. So it's a mediate first clause. This is when you're in the honeymoon period of negotiation. Everyone will agree to that, and this will help us to promote mediation throughout the world. Thank you very much. And if there are any questions and answers, I'll be pleased to answer.
Okay.
If there's time, Dr. Haryanto.
Okay. Thank you very much, Norris Young. Very good delivered speech today. Mr. Young already delivered to us about the interest, starting with the wish list and ending this session also with the wish list. Already explained about the interest-based principles, negotiations, procedure, psychological, substantive, and then interest needs and positions. Also explain negative parameters and positive parameters. Also negotiation process, and by the end of about the mediation pyramids. Yeah. Okay, Mr. Young. By today, I have one already questions to you.
Yes.
The question is the difference between how the participants, the disputing parties, trust to you if the other party already appointed you as their mediator. They say the party A already appointed you, and then the party B, how come he trusts you not interfere or influenced by the first party? How can they trust to you as a mediator? And also, what about the institutions? If they go to the institutions regarding about the appointee, the mediator. This is one of problem for the neutral position, something like that. Thank you, sir.
Okay, let's go to appointment first. If the mediator is trained, well-trained, and has a good reputation as known to be a neutral person, personally, if I was a lawyer acting for a party, I would say choose one of them from their list. It's okay, it doesn't matter. You don't need your one. The mediator, if he's supposed to be neutral, he should not be siding with the person or the party who is trying to appoint them. So there's a misnomer that I must use my mediator. That's not true. Because if you are insisting on your mediator and there's a real reason why you must use the mediator, maybe the mediator is not quite neutral. In fact, I like to choose the other party's list because it shows how sincere I am in the mediation process and in settlement. So if that doesn't work, there should be a clause in the mediation clause that says certain persons or institutions should be the one to appoint the mediator. We'll always have that in as well. So it could be the Mediation Institute, Jakarta Mediation Institute, or whatever institute, have that in so that it's clear if you're going into mediation, try and get somebody else, a third party, to appoint if the parties cannot agree. Okay, second question is related to the trust. How can we get people to trust a mediator? Well, there are three things: trust, respect, and ability. I call them TRA: trust, respect, and ability. They are earned. It's not because they see my CV and say, yes, I can trust lawyers. Well, they may talk to other people, talk to other law firms. Can we trust lawyers? It's like going to a restaurant, a new restaurant. You've never been there. You will ask your friends, hey, is this any good? And you trust your friends to go to the restaurant. But do you trust your friends completely? No, because everyone has their own case. So when we go into a mediation, what we actually do is try and get the parties to trust us and to respect us. And this is done like it's like a bank account. You know, you earn it rupee by rupee. You must earn it slowly, slowly, slowly. And when you earn your trust and the respect, they will tell you more. Okay? And the ability, they will also know you earn that as well. As you go through the process, they see, can I trust this guy? No. And then can I respect him? The more trust and respect they have for the mediator, the more they will disclose their interests as well. And if they feel that you have the ability to help them, they will disclose even more. So we earn the trust, respect, and ability. But you have to be very careful, because if we earned a lot of money in our accounts, bank accounts, sometimes it's very simple. We just ruin it by one very stupid word or action. So we have to be very careful. Just like we see a new car, or somebody sees a new apartment that they really like, they spend all the money, or they spend it on a bag, or I don't know, new toys for the guys. So it's very easy to disrupt that earning. So you must earn it step by step, bit by bit, until they trust you enough. So it's a very complex thing, and it's part of the process to earn that money.
Okay. Okay, Mr. Yang, thank you very much, Mr. Yang. Can you stop the share screen? So,
yes, of course.
Yeah. So the next question is from Mr. Dr. Iwan Erar.
Yes.
Any experience with government enterprise? What constraint? How to face the solution?
Okay. Government enterprises are a little bit more difficult because there are a lot of parameters restraining the government in any of the policies. So you must understand the policies themselves within that department, and understand that you must work with that department. Now, some of the parameters might be skewed in mediation where it involves the government department, such as confidentiality, which is a very key point in mediation. Maybe it requires the approval of a manager from one department, or two departments, or three departments. We don't know. So we have to understand that first. So in the preparation for the mediation, I would have to talk to the person in charge of that department and ask them, okay, let's see, what are the processes? What if we have a settlement? What needs to be done? There was a case, there were cases in Hong Kong where it also needs the Legislative Council to approve it. And that, of course, means that there's public debate and the press is already on it. So that can change things. Now, with the government department as well, the confidentiality is difficult. And another thing is difficult is this: who is going to make the decision? How high up the chain is going to make the decision? Is the person who is attending the mediation, who is reporting what's happening to his superior and then upwards, who is going to finally make the decision? Whoever is attending must feel comfortable that he will be trusted and can be trusted with the reporting. Because if any person higher up doesn't trust what is being reported, it's very, very difficult to get a settlement, because the person is not there. Of course, if the person in charge is there at the mediation, then it's very, very good. Now, there are other parameters such as treaties between governments, if it's an investment in a particular country, but that's really too complex to answer at this moment. We can do that another time. So basically, government mediations are a little bit more complex, but if you get all the parameters done, you do all your homework, you understand what needs to be gone through after you've got a settlement agreement, then it works just like any other mediation.
Okay. Thank you, Mr. Yang. That's a question from Dr. Iwan Erar, lecturer of UPN and the first question is previously come from Dr. Girini, master degree program. Now the next question is coming from the bachelor degree students. I call Mr. Rafael. Rafael, silakan, please. Rafael, you can raise your question directly to Mr. Yang.
Okay. Good morning, Mr. Yang. My name is.
I'm sorry, I can't hear you very well. I'm sorry.
Can you speak louder? Speakernya dibesarin kali. Louding.
Okay. Good morning, Mr. Yang. My name is Rafael. I would like to ask you one simple question regarding the ADR. My simple question is how to ensure whether the ADR outcome is implemented or not between the parties. That's it. Thank you.
I don't quite understand the question. You mean that that the settlement is between the parties?
Yes.
Could you explain to me?
Let me do it once again. My question is how to ensure whether the ADR or alternative dispute resolutions outcome is implemented or not between two parties which has the dispute. Thank you.
Okay, thank you very much for the question. Now, when we have a settlement, we do a settlement agreement. So the settlement agreement is a new contractual agreement, and then all the other agreements before that becomes irrelevant, and we deal with the new settlement agreement. So you have to word the settlement agreement and make sure it's a valid contract, it's enforceable, it's clear, everyone knows what are the parameters, and hopefully it will be enforced. Now, the interesting thing about mediation is because we're trying to get people to agree on the outcome, okay, and not being imposed, they are more likely to execute what they promised. So it's like if you have children at home and they're watching TV and they're not doing their homework, and if you're a judge, like most parents are, I am like that as well too, because we're too concerned about their homework. You see, go to the room, stop watching TV, do your homework, study for your test. So when the children go back to the room, you think they will study? Probably not. But if you're able to convince them that studying for the exam is good for them, that they want a higher grade than last time, that they feel proud that they can do well, they're incentivized, you are encouraging them. When they go back to the room, they will likely read and do their homework. Okay? So the difference between arbitration or litigation, where a judge imposes an outcome on the parties, is different from a mediation where the mediator is facilitating the parties to agree to their own solution. So that their own solution is really important. They must agree to it. Okay? And if they agree to it, they will likely implement it. So there are very few cases, not very many, where a mediation settlement is not executed. But now, with the Singapore Convention, international commercial mediations, if within the members of the convention there is a mediation, they can apply to the country where they want an execution of the agreement to implement the agreed terms. They can do that via the Singapore Convention. So what you just mentioned is something that can be overcome so long as the mediations are conducted within the member states of the Singapore Convention.
Thank you, Mr. Yang. We have two more questions, and then after this, at the end of the session. But allow me to read one question.
Yes.
And the other one, I think Pak Suherman will raise the question by yourself. from Mujiono Hafiz Prastio, he asked if there is a very complicated problem, how to do the proper mediation. Thank you.
Ooh, okay.
From the Penogoro University, yeah. The Penogoro.
Okay. First of all, every problem is complicated. Okay? Please do not think that it's a simple problem. If it's simple, it would have been resolved. Then they can discuss with each other, problem solved. It's never that simple. There are always underlying things which are not seen. Remember the iceberg. So with a complicated or any mediation, we must try and get the facts first. Try and get the facts and do charts, do diagrams, work out what the facts are. Okay, because if we do not know the facts, the past facts, at least the facts that are on top of that iceberg, on top of the water, then it's very difficult. So we must do something we call the 3 P's of mediation: preparation, preparation, and preparation. Okay? You must understand the case very, very well. So sometimes in order to understand the case, you need to go to the parties and understand their parameters. Sometimes you even need to know how decisions were made, why would they were made like this, and understand the personalities of why people make certain decisions. So particularly with government disputes, you have to go through and understand certain policies. You may have to go through some discussions within the parliament, why certain people said this or that, and why this policy was implemented, how it's being implemented. So there's really only 3 things to do when you are dealing with a very complex case. Prepare, prepare, prepare. That's it. You do all your preparation, just like going into a court case. But now you look underneath the paperwork, you go underneath to the bottom of the iceberg to find out what are the interests and concerns. Why did they happen like that? Why were these provisions made? Why were these decisions made? It must have been made with some reasons, and the reasons are involved with the interests and needs and concerns. Okay? Governments have INCs as well. People have INCs. Departments and companies have INCs. Okay? So it's a roundabout way of answering you, but please do your preparation.
Okay, thank you, Mr. Yang. The last question, I think, is from Dr. Sherman, our associate professor. Dr. Sherman, please, you can read your question. Dr. Sherman? Oh, okay. If not, I'll read Dr. Sherman questions. In the mediation process more quickly and effectively. However, the cost of the mediation process will be greater from other ADR. And how strong will the mediation decision for the both parties? Thank you. Please, Mr. Yang.
Okay, I actually think that the mediation cost is very low. For example, the one that I mentioned where I took 7 days. Think about the cost for a 100-day trial. Very, very expensive. You need barrister, solicitor to attend the court, and 100 days. It took us 7 days. 7 days. The 100 day was for one jurisdiction. So if I multiply that by 7, could it be 700 days? Or let's say we do a discount, 200 days. 200 days of court is I don't know, 2 years? Easily 2 years. And then how long would it take for you to get a judgment? It would take a long time because it would be very difficult to even summarize the case when you finish the case. So 7 days was really, really cheap. Now, I think that mediation cost is likely less than 3% of a litigation cost. This is my thinking. Now, lawyers don't like me saying this because it's bad for their business. But we can really resolve many, many cases very quickly. And so the cost is really not high. Okay? When you're dealing with hundreds of millions of US dollars, even spending $100,000 is very cheap. $200,000 is really good. So if it's a small case, even if it's a small court case, it can be done very cheaply as well. You can. There are many institutions that will do that for a fixed fee based on what is in dispute and a small fixed fee. That's definitely doable. So my belief is every case should be mediated first, and if it cannot be mediated, then let's go to litigation or arbitration, and even during the mediation or arbitration, it might be suitable also to go to mediation as well too. So always think about mediation, not as an alternative. Dame Hazel again one time came to Hong Kong and said, you know, people are saying, why should we go to mediation? So she said, let's change the question. Why should we still go to litigation or arbitration when mediation is so effective? Change our thinking. Why should we go to mediation? Why should we go to litigation? Let's stick with mediation first. Do that first. If it's not successful, I understand. Maybe you need litigation, maybe you need arbitration. But even during that process, can we go back to mediation at any point? And I think this is always my message is mediate first. Think about mediation before thinking about anything.
Okay, Mr. Norris Young, thank you very much. It's very, very wonderful and very interesting for all of us. I know you will attend the arbitration session court today at 10 p.m., right? 10 a.m., right? Okay, thank you very much. Before you leave the meeting room, I think why don't you say we'll take a picture with you. Just say like this, Salam Bela Negara. This is our symbol. I can just say, but moment. We'll take a picture first before you leave the room for the next speaker. Mr. Young. Thank you, Mr. Yang. Thank you very much, Norris Yang. Yeah.
Inviting me. I hope to see you in Hong Kong. Maybe not all of you, but certainly. I would like to see you soon. Okay, thank you very much.
Thank you very much. Thank you very much, Mr. Yang. Okay. Thank you, Mr. Norris Yang.
Thank you.
Can leave the room meeting. And the next speaker, I will call Mr. Arya Nakisa, Associate Professor Arya. Are already in the Zoom meeting, Arya Nakisa? Hello? Associate Professor.
Yes, I am here.
Okay, sir. Moment. Allow me to read your CV to the audience. Associate Professor Arya Nakisa, PhD, is education. She is a bachelor in the triple major philosophy, Asian and Middle Eastern Studies, and Religion, University of Pennsylvania, and got also GD, Juris Doctor from Harvard Law School, and Master of Art from in Anthropology and Middle Eastern Studies at Harvard University, and Master of Arts also from about Islamic Law, Fiqh and Usul Fiqh at the International Islamic University of Malaysia, IUM Malaysia, and PhD Anthropology and Middle Eastern Studies, Harvard University. His thesis is Islamic Law and Legal Educations in Modern Egypt. Committee Stephen Skaten, Chair, Brinkley, Mesik, Meber, Jensen, and Asad Ahmad. Yeah, I think now also he is working at previously at Junior Research Fellow, Crown Center for Middle Eastern Studies, Brandeis University, 2012 to 2013, and then after that until 2015, working as Assistant Professor, Department of Religion and Culture, University of Winnipeg, and 2015 until now is Assistant Professor of Islamic Studies and Anthropology, Department of Jewish, Islamic, and Middle Eastern Studies, Department of Anthropology, Washington University in St. Louis. Yeah, and then we have because of this conference, Law and Policy of Transnational Issues, from mediations and arbitrations. Now you go to the different views, cognitive science and the law, study of Islamic law. Furtherly, to Mr. Associate Professor Arya Nakisa, PhD. Please, now you turn to speech, and I hope can deliver maximum 30 minutes and follow with the question and answer. Thank you, sir.
Okay, thank you very much for that introduction. I don't need a PowerPoint presentation, please. I sent a PowerPoint presentation in earlier just because I was asked to do so, but it's not something that I'm going to stick closely to. So, saya mau mulai bersyukur kepada kalian bagi kesempatan ini memberikan presentasi mengenai kajian saya. Saya mohon maaf, tetapi saya belum lancar berbahasa Indonesia untuk oleh sebab itu saya akan menggunakan bahasa Inggris. So the topic that I have, the topic that I will speak on today is cognitive science and the study of law, in particular the study of Islamic law. So over the past 4 decades, there has been a new body of scholarship which has developed and which will impact the future study of the social sciences and the humanities and the study of law in various Western countries and the world more generally. And this body of scholarship which has developed is often referred to as cognitive science. So what is cognitive science? Cognitive science is concerned with evolved psychological mechanisms which produce universal patterns of thought, emotion, and behavior across human societies. In describing these mechanisms, cognitive science draws data from a variety of disciplines, including psychology, evolutionary biology, primatology, neuroscience, history, archaeology, and cultural anthropology. This data includes things like experiments with young children, experiments with human-like apes, scans of human brain activity, statistical surveys about people's beliefs and practices in different societies across the world. Cognitive science research touches on a variety of topics connected to human behavior, ranging from mating to eating to politics to religion. But one major topic in cognitive science is that of morality. And as we'll see, there's a very strong relationship between morality and law. So cognitive science research suggests that all human societies share a set of intuitions about morality, and that these intuitions underlie every system of norms or laws found in the entire world, including the norms which constitute Islamic law or the Sharia. So today I'm going to speak with you a little bit about cognitive science and universal moral intuitions and how they relate to human legal systems. And I will discuss this topic in the context of Islamic law. So before getting started, I should probably cover a couple of preliminary points. One is the question of what is an intuition. An intuition is a belief that emerges naturally in one's mind, and it might be conscious or it might be unconscious. So people have a variety of beliefs relating to morality, which are natural and often unconscious. So what are some examples of these type of moral intuitions? One moral intuition is that you have a moral obligation to care for people who are your blood kin. You have a moral obligation not to engage in incest. So for instance, not to marry or engage in sexual relations with your family members. You have an intuition that you should not lie. So these would be some examples. Now, as we'll see, there are many, many different intuitions, but these would be some examples of universal moral intuitions. So these moral intuitions are innate, which means that they do not need to be taught. Children are born with these intuitions. They spontaneously develop them at certain ages. And usually these intuitions are explained with reference to biological evolution. So it is believed that the moral intuitions that we have, the moral intuitions that humans have, are beneficial to them in the sense that they aid in their survival and reproduction. So for instance, one reason why people have an intuition that they should refrain from incest, refrain from sexual relations with their family members, is because children children who are born from sexual relations with family members tend to have birth defects and die. So in other words, sex with family members prevents people from reproducing healthy children who carry their genes. So that's just a very simple example. When people claim that humans across the world have a variety of intuitions about morality, what types of evidence do they cite for this? Well, one is evidence from developmental psychology. So for instance, you can ask young children who are 3 years old, 4 years old, in some cases younger, about their perspectives on different moral issues. So you can ask them, do you feel that it's wrong to lie? Do you feel like you have an obligation to take care of your family members? Another source of evidence that you can use if you're interested in the subject of intuitions is biology. So you can look and see if there are patterns that exist among other animals. So maybe if you believe that humans have a moral intuition that they should take care of their family members, you see if other animals also take care of their family members. Or if you think that human beings have a moral intuition that they should avoid incest, you go ahead and you see as well, maybe other animals also have also avoid incest. And especially there is attention given to primates and chimpanzees and bonobos because they are very similar to human beings. You can ask, do chimpanzees avoid incest? The fact that chimpanzees avoid incest indicates that there is probably some cross-species biological mechanism which encourages organisms to avoid incest. You can also look at neuroscientific evidence, so brain scans or experiments involving hormones. So for instance, if you scan someone's brain and you see that parts of their brain which are associated with pleasure activate when they help their kin, that is evidence that people have an intuition or people have a motivation to help their kin. If there are parts of the brain associated with disgust, that activate when they see pictures of people engaging in incest, that's an indication that human beings by nature find incest to be disgusting. And then you can look at historical and anthropological studies. So historians and anthropologists will study different societies across the world. They will go to different societies across the world and they will see, well, what moral beliefs are shared by all of these various societies. So moral intuitions provide us with a motivation to act or not act in a particular way. So we can have an intuition that it's wrong to engage in incest or that we should help our family members, and that will motivate us to act in that way. But oftentimes moral intuitions are often associated with emotions as well. So humans have not just evolved this set of emotions, they've also evolved a variety of people haven't just evolved a set of intuitions, they've also evolved a set of emotions which are related to their intuitions, like feelings of guilt, anger, love, disgust, and gratitude. So for instance, one reason why you might help your family members is you feel like you are morally obliged to do so, but you might also have a feeling of love for them, and that motivates you. One reason why you might refrain from engaging in incest is you think that you have a moral obligation to refrain from this action, but it just makes you emotionally feel like it's a disgusting act. So our moral intuitions and our emotions are closely related to one another. So all legal systems that exist, whether we're talking about religious legal systems like Islamic law, like Hindu law, like Jewish law, whether we're talking about secular legal systems like contemporary American law, contemporary Chinese law, all of these legal systems have rules, and these rules are seen to be rules that reflect moral standards. And these moral standards are ultimately based, to some extent, on universal moral intuitions. So one question that someone might have is, how many moral intuitions are there? This is a matter of debate among scholars of cognitive science. Some scholars posit less than 5. Some scholars posit 10 or more. Perhaps the most famous list comes from what is known as moral foundations theory. It's It's associated in particular with Jonathan Haidt, and he claims that there are at least 5 moral intuitions. But he posits there are probably more. So today I'm going to briefly go over a list of 6 moral intuitions for which there is a lot of evidence and which have received a lot of attention from researchers. And I'm going to explain how they can help us understand the type of rules that we find in Islamic law. So these 6 intuitions that I'm going to talk about are the following. The first relates to property rights. The second relates to care for kin. The third relates to loyalty for one's group. The fourth relates to positive reciprocity. The fifth relates to negative reciprocity. And the sixth relates to disgust. Okay, property rights. Let's talk about the first intuition. So humans have an intuition. Humans intuitively believe that property rights exist and they should be respected. And in fact, property or certain forms of behavior tied to property are not simply limited to human beings. They can also be found in various animals, including primates, but other animal species as well. So for instance, when we talk about chimpanzees and other animals, one feature of their behavior, which is very important, is territoriality. They have a particular territory that they guard. If another creature comes onto their territory, they will fight off that creature. Similarly, one thing that you see with chimpanzees is they have a respect for food items which are possessed. So if one chimpanzee is holding a banana, other chimpanzees, even if they're stronger, will not try and snatch the banana away. There is some kind of respect. There is a reluctance to go ahead and take something away from an animal, or from a chimpanzee, if that chimpanzee already has that object in its possession. So not only do we have this animal evidence, but when you ask young children in the first few years of life about their views about moral issues, they have a very developed intuitions about the nature of property. And these intuitions are found in children from different countries across the world. So they have beliefs that you should take someone else's property. They have particular beliefs about how to acquire property. So for instance, the first person who possesses an object is the one that owns it. Or if you transform raw materials into an object, you have a ownership claim over that object. So those are just a few basic examples. Now, property rights have a significant place in legal systems across the world. What varies in legal systems across the world is which laws they design to protect property rights. So to some extent, these follow common principles. To some extent, they are different. But one reason why we know that property plays an important role in Islamic law is that this is something which is explicitly articulated by pre-modern Islamic jurists. So among pre-modern Islamic jurists, there's a particular theory about what the aims of the Sharia are, maqasid al-Sharia. And one of these ideas is one aim of the different rules of the different laws that are found in the Sharia is to protect property, hifth al-mal. So that is one of the maqasid of the Sharia. You also have different hadith from the Prophet where he talks about how part of his mission or part of the Islamic message involves protection for property rights. So there's a hadith which recounts a speech made by the Prophet Muhammad at the end of his life during the farewell pilgrimage. And he says, quote, "Verily your blood, property, and honor are sacred to one another like the sanctity of this day of yours, in this month of yours, and in this city of yours. It is incumbent upon those who are present to inform those who are absent." So here you have a situation where the Prophet says your blood, your property, and your honor are sacred. So property is seen as something which is sacred. More generally, the notion of property rights underlies a vast number of more specific Sharia rules. These include rules pertaining to theft, to loans, so iqrad, to renting, ijara, to gift giving, hibba, to sale or bay', to rules for acquiring ownerless property. We can go over a couple very simple examples. So for instance, one of the famous Sharia penalties, one of the hudud penalties, is a penalty for theft or sadaqah, which involves, albeit under a very limited set of circumstances, amputation of the hand for the theft of property. Similarly, there are beliefs about if someone has ownership of property, they're entitled to transfer it to another. So one intuition that people have about property is that one of the things that it means intuitively for human beings to have a property right is if you have property, you're entitled to transfer it to others. That intuition underlies various Islamic legal rules pertaining to gifts. You're entitled to give your property to others, and also to sales. You're entitled to sell your property to others. So that's an example of how some rules in the Sharia are shaped by these moral intuitions concerning respect for property. And this is also found in, let's say, the Indonesian legal system today. So the Indonesian legal system today, someone could do a cognitive analysis of all Indonesian law that exists today and talk about the type of rules that exist for protecting property in Indonesia, draw on these principles, and they could also point out in what ways they're unique and what ways they're not unique. So perhaps one aspect of Indonesian law when it comes to protecting property is, yes, it agrees in protecting property, but it doesn't use corporal punishments to do so generally. Perhaps it uses fines or jail time instead. So in talking about universal moral intuitions, the point isn't to say that all legal systems are the same. Clearly, that is not the case. Clearly, cultural differences play a role. Clearly, economic and technological developments play a big role. However, there are also similarities as well. Okay, what's the second moral intuition? A second moral intuition is care for kin. So people intuitively believe that they have a moral obligation to care for kin, especially those who are closely related to them. And this principle of care for kin recurs over and over in the Quran and the Hadith reports. So for instance, the Quran, Surah 16, verse 90 says, "Verily God commands justness and kindness in giving to relatives." So ita dhil qurba. And in fact, Islamic law lays down specific rules. So for instance, if you are a father, you are obliged to give financial support to your children. And also, if you are a child, you are obliged to be dutiful to your parents, bir al-walidain. And one of the things that involves is caring for them in their old age. Caring for them meaning providing them with food, if necessary, providing them with shelter, if necessary, kindly treating them, not saying oof to them. And indeed, the emphasis on care for kin is not just something that extends throughout a person's life, but even extends after their death. So one of the things that you have to do is you have to take care of your kin after they die. A major way that you do that is through inheritance law. So for instance, the Sharia says that everyone is obliged to give their property through inheritance to their family members. You can't just give your property to whoever you please, because your obligation is specifically to take care of your family after you die. So that's another example. Let me move on to a third intuition. A third intuition is that everyone should be loyal to the community of which they are a part, to the group of which they are a part. Now, groups, human beings naturally perceive themselves as members of a group if they share distinctive characteristics with that group. So if they share the blood with the group, so they're a member of the same race or tribe, suku or ras, they might share religion, they might share culture, they might share some combination of the above. So for instance, Indonesian people think of themselves as one group, which is Indonesian, and they feel that they have an obligation to be loyal to one another and take care of one another. This is one of the principles that underlies, kebangsaan Indonesia, so Indonesian nationalism. So humans intuitively believe that they should go ahead and protect their group, especially in situations of conflict over resources. This is a view that you also get in Islam. So Islam says all Muslims share particular characteristics. They share a specific set of rituals. They share a specific set of beliefs that makes them one nation or ummah, and they should cooperate to protect one another. So for instance, if Muslims are attacked, they should protect other Muslims, and rules such as the rules of jihad are laid down for that reason. Fourth intuition is that of positive reciprocity. So positive reciprocity basically means if someone people believe that they have a moral intuition. If someone does something good for you, you are morally obliged to do something good for them. So for instance, if I help you harvest your crops, if I give you some food, you should respond by giving. Saya mohon maaf, saya tidak bisa berkonsentrasi. Apakah Anda bisa? Fourth intuition concerns positive reciprocity. That means if someone does something good to you, you're morally obliged to do something good for them, which is similar. This is a principle that you find in Islamic law. It is discussed by Muslim jurists and theologians under the topic or under the heading of Shukr al-Mun'im. But for instance, we have this in Islam. The idea is, for instance, if your parents do something good for you, like take care of you when you're young, you're obliged to do something good for them. Spouses do kind things for one another. So for instance, the husband provides for the wife, and the wife also helps the husband by, it can be through housework, it can be through being taking care of the kids. At least in the pre-modern period, these are common ideas. Moreover, this idea underlies Islamic notions of worship. The idea is that God has done all of these nice things for human beings. God has provided with human beings with food to eat, and he has provided them with healthy body parts that they can use they have eyes that they can use to see. They have arms and legs which they can use to walk around. These are all good things that God has done. So hence human beings, just as God has given human beings benefits, human beings are morally obliged to try and please God. And they can do that through expressing their thanks in worship, but also through obeying his laws. A fifth moral intuition is that of negative reciprocity. So negative reciprocity is if someone harms you, you are morally entitled to harm them back to an equal extent. So for instance, if you break my arm, I am entitled to break your arm. If you destroy my TV and cause me $500 worth of damage, I am entitled to cause you $500 worth of damage. So this notion of negative reciprocity underlies a variety of Islamic legal rules, most famously, or most obviously, the rule associated with qisas. So kind of the tort rule, where if someone physically assaults someone else or kills someone else, so Islamic law says, traditional Islamic law says, if someone destroys your body part, you are entitled to destroy their body part or the same body part, or they are supposed to pay monetary compensation. You also have that option, or you also have the option of forgiving as well. So a sixth and final intuition concerns that of disgust. So humans have evolved such that they feel disgust. They have a particular emotional reaction upon encountering certain types of substances and behaviors. And what all these substances and behaviors have in common is that they cause disease. Historically, they are vectors for pathogen transmission. So some things that all human beings find disgusting are the following. One is bodily secretions, like vomit, pus, semen, feces, urine. One is decaying plant or animal matter, like spoiled milk, rotten vegetables, or dead bodies. Another is sexual behavior, like incest, promiscuity, bestiality. And another is unfamiliar or unhygienic animals. So for instance, if there is some type of animal that you're not familiar with, like a bear or a bat, you will not feel comfortable eating its meat. You'll feel comfortable eating certain types of meat that you ingested in your youth, like for instance, maybe chicken, maybe beef. But if it's something like a crocodile or a scorpion, something you've never had before, you will find that disgusting to eat. And you have these, you have many Islamic legal rules which relate to disgust. So Islamic legal rules emphasize purity, they emphasize tahara, they emphasize staying away from disgusting things. So individual Muslims should keep their bodies pure, and they should also keep their spaces pure. One of the things that involves is eliminating disgusting bodily substances. So for instance, if you go to the bathroom, you need to wash yourself afterwards. That's istinja. Before, you need to constantly wash yourself by making wudu before you pray. If you have sexual intercourse, so if there's an emission of sexual substances like semen, you need to go ahead and engage in ghusl. You need to wash yourself. Also, Muslims are obliged to refrain from sexual behaviors that are seen by human beings naturally as disgusting. So one is bestiality. Sharia says you're not allowed to have sex with animals. You're not allowed to have sex with your relatives. You're not allowed to engage in promiscuous sex. And then finally, there is the issue of unfamiliar animal substances. So the Sharia goes ahead and it allows certain types of animals to be eaten, but most animals are considered to be, there are restrictions on eating other animals that are seen as disgusting. So this would be, an example would be pig or dog. We can't get into all of these details. These are just a couple, because my time is pretty much up, but these are just a couple of indications of how a cognitive science perspective can shed some new light on specific rules that are part of Islamic law. But the lesson is more general. You could take Jewish law, you could take Hindu law, you could take contemporary Indonesian law, you could take contemporary Chinese law, and you could ask to what extent different rules, which are found in that legal system, are tied to natural human intuitions that come from the human mind. Okay, so I will go ahead and end there. Thank you very much.
Thank you very much, Associate Professor Arya Nakisa. Actually, Arya, you still have time to have a panel with us, waiting for the other speaker, sir?
I have a time to answer some questions. Okay. If there is interest in that. I mean, I can stay on for about another half hour, but after that, I need to prepare for teaching tomorrow.
Oh, I see. So we have a question now. Okay, allow me to read one or two questions to you. I allow to Dr. Iwan. Dr. Iwan Erar, want to raise your question? Please, you can directly speak now. Actually, sorry. Allow me to conclude a little bit about what is Associate Professor Arya Nakisa told to us about the cognitive science and the study of Islamic law. Is mentioned about 6 moral institutions that have received the most attention by researcher. Yeah, property rights, care for kin, care of in group or royalty, positive reciprocity, negative reciprocity, and disgusting stuff. Yeah, I think that's all for your presentations. And please, Dr. Iwan Erar, if you want to raise a question, please.
Thank you, Dr. Imam.
You're welcome.
My question is for Mr. Nakisa. Islamic law is the completed cognitive science. Yeah, we understand about the principle of balancing and equal. Yeah? But the problem is why so many people misunderstand to the Islamic law, and what the constraint from your side and how to give the solution, especially in the Indonesian system law.
Okay, so why do people misunderstand Islamic law? It's a good question. I think one thing that people, sometimes Islamic law seems very foreign to people, but one way of indicating that one way of helping people appreciate the logic of Islamic law is a cognitive science can help in that, because it can help us appreciate, okay, there are different legal systems across the world, but to some extent, they are based on similar moral principles. So I gave the earlier example about different ways of punishing crime, but different ways of punishing people for property rights violations. But one can think of other examples. So for instance, there are many different legal systems across the world believe in care for kin, and for that reason require that people pass on their property to their kin when they die. But Islamic law has very specific inheritance rules. So the inheritance rules that you find in certain countries, including within Indonesia, if you look at some of the adat traditions, they do not necessarily conform to Orthodox Islamic law. So there are similarities in the sense that all of these different legal systems acknowledge that care for kin is important. On the other hand, they seek to care for kin in different ways. So I think one way to help people understand is to show how these different legal systems share a particular set of moral intuitions. And it's also to help people understand how every legal system, whether we're talking about contemporary legal systems or whether we're talking about legal systems from the pre-modern era, how their specific rulings are always shaped by their specific cultural background and also the types of technology and economic structures that are characteristic of that era. So that would be part of an answer. I hope it
Thank you,
useful.
Professor Arya. Next questions from Mr. Isman. What do you think about Pancasila with the principle of parenthood, social justice, and transcendental humanity can be survived in the dramatic changes in the Industrial Revolutions 4.0 and 5.0 of society survive?
It's a very interesting question. Many scholars will say, I read, there's a book that I think is somewhat interesting on this topic. It's called Homo Deus by Yuval Harari. And basically the problem that faces Indonesia is not a uniquely Indonesian thing. I don't even think that it's limited to Pancasila, but basically the type of technological changes that are tied to things like Fourth Industrial Revolution, where you kind of have human beings merging with machines, merging with AI. When you start implanting things into human beings and altering the human body and altering the human mind, whether it's through genetic engineering, whether it's through brain implants, you quickly will move on to a situation in which there is nothing which resembles human beings anymore. So imagine someone says this, imagine someone says, I don't want to feel sad anymore. Let me take some pharmaceuticals, or let me change my mind such that I no longer feel sad. I no longer feel lonely. Imagine someone says, I don't even want a human body. I want to replace different parts of my body because this human body is going to die off after 80 years. Instead, if I have like a silicone body, maybe I can last, 200 years. This is quickly going to lead to a situation where there's nothing that resembles human beings anymore. Many people think this is overwhelmingly probable, although it would happen step by step over the next 150 to 150 years. That is going to be a big challenge for every nation in the world, including Indonesia. But if the predictions that we have are correct, there will be nothing resembling Indonesia, nothing resembling humans 150 years from now. That presumably means Pancasila is an ideology for humans that makes sense for humans. But if you talk about transhumanism, beings that are somehow beyond. So for instance, one thing about Pancasila is Pancasila presumes that there is an Indonesian national identity, that it's worth preserving Indonesian group identity and language and culture. Maybe humans in the future will be created who don't care about preserving their identity. Maybe they will just be all atomized, individualistic consumers. So I'm sorry that the question isn't easy to answer, but I don't think there is a huge challenge for Indonesia, but it's a challenge that is shared by every group of human beings across the world.
Yeah, okay. Thank you, Professor Arya. And the next questions I call Ms. Liva Wadila. Okay, you can raise your question by yourself directly to Professor
Yes, sir.
Arya. Yeah, oh, Mr.
Yeah.
Liva Wadila, yeah, okay.
Yeah. Good morning. Permission to ask Ms. Arya Nafisa.
My pleasure. Please go ahead.
My name is Liva Wadila, law student of University Veteran Development Unit, Veteran Jakarta. As is well now, the Earth is threatened with various environmental cases, either caused by the development activities of a country or by transnational corporation, companies investing in developing countries. The economic power of transnational corporation will no doubt be referred to as TNC is. The company is a global economic driver. TNC has the ability to further and control international trade, investment, and technology transfer. However, it is not uncommon that TNC in developing countries such as Indonesia have contributed to environmental problems, both in the form of environmental damage and environmental pollution, so that the right of citizens to enjoy a healthy environmental are violated. How do you deal with problems like this? Thank you.
It is a real challenge, and I have to say that I don't have environmental issues are not my area of expertise, but there are some things, I mean, things like nuclear weapons, things like the environment, things like COVID that can only really be solved through coordinated international action. And if there's not agreement by all nations, they cannot be solved. Unfortunately, we live in a world where there are certain international corporations that are not really accountable to any single nation. And you also have certain countries who believe that they are entitled to make laws for the rest of the world without input from other nations, especially those nations which are weaker economically or militarily. One can only hope that those positions will change and that the globe will move towards, perhaps through international institutions, that there will be more, that there will be more of an emphasis on addressing certain global issues in a manner which reflects input from all peoples. Environment is obviously one of them, and one would hope that Indonesia would be given a voice commensurate with its importance and its population size in terms of crafting policy. So that's all I have can really say about that.
Thank
issue.
you.
Yes, thank you. Before.
Thank you. Thank you, Devi. Yeah. Last question to you, Professor Arya, from Rinda Amal. How we put a lot of value and perspective into one valid regulation that's suitable for all peoples?
Well, one thing that, I mean, so one idea that one might have, at least to the extent that this might be related to the presentation that I gave earlier, it does seem that human beings share a certain set of moral intuitions about the world. And laws might be crafted to take those moral intuitions into account. Although one of the things that we can say is that existing attempts to craft laws that are applicable across the world don't necessarily take all of these moral intuitions into account and often reflect the legal culture of a specific country. So for instance, international human rights norms tend to reflect a Western, kind of a Northwest European and American perspective on the world. So to some extent, I think it is desirable to try and arrive at principles that everyone shares. But one principle that I think, or it could be argued, and there is evidence from cognitive science to this effect, that one principle that people across the world care a lot about is self-determination for different groups. Different groups want to preserve their culture, they want to preserve their way of life, they want to preserve their sovereignty. And sometimes international roots, human rights initiatives don't necessarily give as much weight to the distinct culture and sovereignty of different nations. So probably there needs to be a balance between trying to come up with principles or laws applicable across the world, but also recognizing that those laws are always going to need to be modified in order not to interfere with or undermine the sovereignty of different nations or this distinctive traditions, religious and cultural, which underlie that nation's identity.
Okay. Thank you very much, Professor Irena Kisa. I know in Washington it's already late night, already 10:30 p.m., right?
Yeah.
Okay, then before you leave us the meeting room, can I take a picture of Salam Bela Negara? Salam Bela Negara.
Sure, so like this.
Yes. Thank you. Okay. Excellent. Thank you. That's Professor Irena Kisa. Thank you very much. And the next speaker, we still have three persons, Professor Hartini Saripan, Carmela Kasim, and also Professor Iqbahanto Juwana. And we'll be settled by panels, yeah, because they have time to join with us and sharing and discussing with us. Okay. Thank you very much. Then I will check Professor Hartini Saripan. Are you there? Join with us already?
Yes, Dr. Imam, I'm here.
Thank you very much. Before that, allow me to read your brief CV. Yeah? Hartini Saripan is Associate Professor at the Faculty of Law, University Teknologi Mara, Shah Alam, Malaysia. She serves UITM for almost 18 years and is currently a Dean of UITM, yeah, University of Teknologi Mara. She read law at the International Islam University, Malaysia, and received her PhD in law from UITM. She started her research work on cyber law, focusing on electronic commerce and digital signature law. She has later expanded her work to delve into technology law, specializing on robotic law and artificial intelligence. Her research works were funded by several national grants, including the Fundamental Research Grant Schemes and Needs Research Grant Scheme. She was also awarded with the other grant by external and internal funders such as Jawatan Kuasa Pembaharuan Undang-Undang Malaysia. In addition, she supervised master and PhD candidates in the area of the law governing rehabilitative and assistive robots as well as electronic conveyancing. Not only that, she has presented her research work at the international and national conferences, such as in Istanbul, Shanghai, Bangkok, Singapore, and Jakarta. She also authorized and co-authorized several articles in the flagship and indexes journals. As a pioneer researcher of robotic law and artificial intelligence in UITM law, she hopes to develop this dynamic area in order to prepare Malaysia for an enormous and unpredictable technological innovations and revolutions. And for the delay, I think she will speak about toward a sustainable online dispute resolution for cross-border e-commerce. Please welcome Associate Professor Hartini Saripan. Now your turn, please. Not more than 30 minutes, yeah.
Thank you so much, Dr. Imam. Is my voice clear enough, Doctor?
Yes, very clear, very clear.
Okay, hello, Assalamualaikum, good morning everyone. Apa khabar? Saya doakan rakan-rakan semua di Indonesia, di Malaysia, Hong Kong, Singapore dan di mana-mana saja berada dalam keadaan sihat dan baik. Greetings from Malaysia. So allow me to continue my talk in English. It gives me a great pleasure to be here today. And before I begin with my talk, I would like to thank the rector of UPNV Jakarta, Dr. Abdul Halim, the Dean of Fakultas Hukum UPNV Jakarta, and my dear friend Dr. Imam Haryanto for inviting me. So just like Arya, I don't have slides, and I really hope I will be able to engage with all of you and to share something that is very close to my heart. So ladies and gentlemen, today I'm going to talk about the issue befitting the current economic and global health landscape. So the global nature of COVID-19 pandemic has resulted in massive disruptions to the ordinary course of business and operations around the world. It is in fact inevitable that the adoption of digital technologies and services is significantly accelerated as a result of the pandemic. Therefore, in order to keep trade flowing, despite the fact that our movement is restricted, digital trade, including electronic commerce, is the answer. In fact, this is the best solution to global economic recovery. So therefore, ladies and gentlemen, we cannot deny the fact that COVID-19 has thrust e-commerce into the limelight, compelling struggling businesses to try out new sales avenues and strategies to survive, not only in local markets, but also overseas. So businesses are taking important steps to boost online sales in the international market. Therefore, it is definitely not confined. So these transactions are not confined to domestic sales because it is extended to cross-border e-commerce. In the era of globalization, e-commerce transactions that span multiple jurisdictions and markets have unfortunately fallen prey to this new and unexpected risk presented by the current health phenomenon. So as we all know, the degree of intimacy and extension of electronic-based relationship of e-commerce players is far more limited, which exposes them to a greater risk. As a result, disputes in cross-border e-commerce are amplified and heightened between consumers and traders. So ladies and gentlemen, the question here is, are these consumers expected to undertake the traditional approach of civil litigation or resisting dispute settlement mechanisms to solve their disputes, or is there a pressing need for a new approach? We are very fortunate that this morning we listened to Mr. Norris Yang of Hong Kong. His vast experience, particularly in the ADR in Hong Kong. So today, I hope I would be able to share with you another spectrum of ADR, specifically focused on the context of e-commerce, cross-border e-commerce disputes. So I'm going to share with you today some discussions on sustainable online dispute resolutions for cross-border e-commerce disputes. And I will divide my talk to 4 parts. The first part, we are going to talk about the trends of cross-border e-commerce disputes. And after that, we are going to see what are the challenges in traditional civil litigation and the existing dispute settlement mechanisms. And then we will move on to the third part, which is the crucial part of my talk, that is the instruments and the initiative, the framework of online dispute resolutions. And then I will end my talk with some of the key issues surrounding the implementation of online dispute resolutions. So let us begin with some of the trends of e-commerce disputes. that involves trans-border transactions. With the growth of e-commerce, there seems to be an increased cases in cross-border e-commerce disputes, which concern with none other than the protection of consumers and their rights. So in this case, shortages and logistic bottlenecks are commonplace because COVID-19 continues to disrupt the movement of products and raw materials along global supply chains. Therefore, as a result of that, many businesses have been unable to deliver goods and render services in the ordinary course, and they are worried that they may be in breach of their contractual obligations, or that the other party to their agreements may fail to perform entirely or partially their contractual obligations. So if a contract to deliver goods and supplies cannot be performed, the lack of goods and supplies under one contract may result in an inability for the affected party to meet its obligation under other contracts. So there are many factors that cause an online dispute. Some of the uncommon factors include misleading product information, defective products that are not satisfactory quality, as well as unsecured websites. However, ladies and gentlemen, we have to understand here the trickiest part of e-commerce disputes is that they usually involve high volume with low value transactions. So with that, we will come to the second part of my talk, that is the challenge, or what are the challenges in the traditional civil litigation and the existing dispute settlement mechanisms. To begin with, litigation is the first choice when attempts to reach a reasonable solution is unsuccessful. And there are other alternative dispute resolutions mechanisms, including credit card chargeback mechanisms, merchant complaint resolution mechanisms, and these would normally embed in the ADR agreements. And then we also have complaints to governmental authorities, consumer protection agencies, and small claim courts. However, the concern is apparent, and this was revealed by the EU Digital Single Market Consumer Survey, that most problems with purchases online were not properly remedied. And even where the problems were addressed, it was likely that they would result in a satisfactory solution for the consumer. So when disputes arise from electronic transactions, cross-border proceedings can turn out disproportionately costly and lengthy. And even where judgment was obtained in the consumer's favor, costs and efforts are required to enforce it against the trader. So in addition to that, the litigation possibility in foreign courts and differences in the laws applicable to the contract would also make businesses abstain from engaging in cross-border electronic transactions. So these issues would definitely become a barrier to e-commerce development. Hence, the disputes arising from e-commerce can be difficult for courts to deal with because of several reasons, such as questions as to the applicable law. This is pretty much choice of law, the high volume of claims, differences between the litigation for high cost transactions and claims for low value transaction, and the difficulty of enforcing foreign judgments. So for these reasons, the demand of ADR is increasing exponentially around the world, especially online dispute resolution, taking into account that we are in a very difficult and challenging situation where our movement is restricted, that face-to-face interaction is almost impossible. So we need something that is fast, efficient, flexible, and more importantly, inexpensive mechanism for handling e-commerce both at the domestic level as well as international level. Because we have to bear in mind that in most of e-commerce disputes, they usually involve high volume with low value transactions. Now, I've come to the third part of my talk where we are going to see some of the instruments of online dispute resolution. As I mentioned, it is necessary for policymakers and businesses to provide an appropriate redress mechanism for dealing with disputes arising from e-commerce transactions. So at the moment, online dispute resolution seems to be one of the best appropriate mechanisms for dealing with disputes arising from such e-commerce transactions, again, because mostly they involve high volume with low value transactions. So it can help parties resolve disputes in a simple, fast, flexible, and more importantly, low cost method without requiring a presence at a meeting or hearing. So let me share with you one of the initiatives. This is basically the United Nations instrument. The United Nations Commission on International Trade Law, UNCITRAL, decided to undertake work on online dispute resolution way back in 2010 in New York. So it established a working group to embark on developing online dispute resolution mechanisms relating to cross-border e-commerce transactions, including business to business and business to consumer. So according to this working group, ODR is a mechanism for resolving disputes facilitated through the use of electronic communications and other information and communication technology. So the process may be implemented differently by different administrators of the process and may evolve over time because, as we all know, anything that has got something to do with technology will not definitely be stagnant. So it will evolve and develop robustly. So UNCITRAL technical notes on online dispute resolution outline several principles underpinning the implementation of ODR. And these includes number 1, impartiality, number 2, independence, number 3, efficiency, number 4, effectiveness, 5, due process, 6, fairness, and last but not least, accountability and transparency. So as far as this UNCITRAL instrument is concerned, UNCITRAL has actually come up with the ODR package model, and they have actually considered this package model, which consists of 3 stages. Number 1 is negotiation, number 2 is facilitated settlement, and the last one, the final stage, which it will definitely end with the award. This is what we call arbitration. Now, these 3 processes have actually formed a framework for the implementation of ODR at the local level. So the ODR process, number 1, would start with the claimant or claimant submits a claim through the ODR platform to the ODR administrator. And later, the ODR administrator would notify the respondent of the existence of the claims, as well as notify the claimant of the response by the respondents. And then at the negotiation stage, the disputed parties directly negotiate with each other through the platform operated by the ODR provider using electronic communication without any intervention of the third party as a neutral person. So if this negotiation stage fails, then the parties would move on to a second stage of what we call a facilitated settlement. And during this stage, an intervention of a neutral third party takes place as the ODR administrator appoints a neutral adjudicator for communicating with the parties and attempt to support the parties to reach a mutually acceptable settlement. Now, if the dispute remains unresolved, then the process may finally move to the third and final stage of arbitration, and in this final stage, the case is decided by an impartial neutral party, and the decision of this award is enforceable. Now, that is basically the instrument by UNCITRAL. Let me just share with you the initiative at the ASEAN level. The ASEAN has also come up with a strong initiative to kick off online dispute resolution framework. So the ASEAN Economic Community, AEC, highlights the development of a regional legal framework for online dispute resolution for facilitating e-commerce transactions in ASEAN. So the AEC Blueprint 2025 this calls for action to adopt an agreement on e-commerce, including several strategic measures. So in order to implement these strategies related to online dispute resolution under the AEC Blueprint 2025, the ASEAN Strategic Action Plan for Consumer Protection 2025 was adopted upon work on consumer protection of the ASEAN Committee on Consumer Protection. So this strategic action has set the online dispute resolution mechanisms of ASEAN in its strategic goal, where the high consumer confidence and cross-border commercial transactions shall be instituted, and an appropriate regulatory framework and enforcement measures shall be ensured. The strategic actions lays down reference material for ASEAN member state to develop their own action plan and establish an online dispute resolution system, which is in line with the strategic actions recommendations. Ladies and gentlemen, I would also like to share with you some of the examples of ODR implementations worldwide. And I will highlight several jurisdictions. And let me begin with the EU. The European Union, by virtue of the regulation on consumer online dispute resolution, which was entered into force way back in 2016, introduces specific ODR processes for disputes between consumers and traders based in the EU. So according to this specific ODR framework, the EU ODR platform offers a single point of entry of consumers and traders to resolve disputes arising from both domestic and cross-border e-commerce transactions through an interactive web interface without being together physically at a meeting room or going to court. So consumers may initiate a procedure by submitting a complaint electronically to a trader, and the trader can identify the competent ADR entity. So when the ADR body is mutually chosen, the parties transmit the complaint to that body. And this platform also provides free translation of information necessary to all relevant actors for the dispute resolution. So that is in the EU. Now, in China, and of course, China is quite advanced when we talk about these ODR platforms, and they have divided their ODR platforms and framework into 4 categories. Number 1 is professional ODR platforms, and this ODR is specifically for domain name disputes through the Asian Domain Name Dispute Resolution Center and the Online Dispute Resolution Center at the China International Economic and Trade Arbitration Commission. So that is the first platform, the international ODR platform. Secondly, the ODR platforms dominated by People's Court, and this is specifically for online mediation platform and online trial platform. And many local courts set up these online mediation platforms, and they call it e-mediation. So the third platform is ODR platform dominated by judicial administrative departments. And these judicial administrative departments set up ODR platforms with People Conciliation Committee, media, and other institutes. So for example, they have this Judicial Bureau along with broadcasting group establish the online mediation platform, and they call it Bayou Peacemaker. And the last platform is ODR platforms established by e-commerce websites. And such online dispute resolution platforms are mainly used for coping with online shopping disputes between online consumers and online sellers. And most of their online merchants and their online shopping platforms have their own ODR mechanisms. Now, what are the key challenges in implementing ODR? This is basically the final part of my talk, and I thought this is very important for us to understand. The first key challenge is the issue of trust. Now, we have to understand that the neutral party must be perceived by the disputing parties as neutral and trustworthy. In a face-to-face environment, trust develops as the parties assess the disposition of the third party through sensory and mental processes. So we can really, do it physically to engage, and there is engagement between the third party as well as the disputing parties. However, in an online environment, a gap exists as a result of the remoteness of the people involved in the dispute resolution. Therefore, in an online process, the disputing parties do not know each other, and they have no real relationship whatsoever with each other. So this basically presents the third party with the challenge of drawing on skills that are outside those required for traditional ADR processes. So definitely for ODR to be kicked off successfully, there should be extra and additional skills that needs to be acquired, particularly by the neutral third party. Second issue or second challenge, key challenge, is with respect to data security and confidentiality. For the ADR procedure to be successful, confidentiality is essential. In an offline procedure, confidentiality is not really a problem. It is a problem, but it is not as crucial as the online platform or online environment, because most communications are oral, and sometimes transcripts of conversations are not usually made. So any written documents that do exist only circulate in a very small group of people. And this is definitely different with online environment or online communication, because the communication takes place in a written form over the networks. So to transfer the data over the internet, there are numerous temporary copies made along the way. And this would definitely pose a challenge and a problem, in ensuring that the platform, the ODR platform use is safe without any tampering, from the non-related parties. The next key challenge is privacy. Where privacy is concerned, parties should be made aware of their ways in which privacy is protected, and in what ways personal information is stored and used by the neutral party, either the mediator or the arbitrator or the adjudicator. So it is imperative that this third party should have a privacy policy which addresses several issues, and any dispute that they receive via a website must be treated in accordance with rules of confidentiality. So the disputes must only be known to the parties involved in the dispute, including only a constraint to the third party. So all personal data must be recorded and used with great care. So this basic security requirement is very important in order to ensure the success of online dispute resolution mechanism. And the last challenge is compliance. And it is no use to enter any dispute resolution process if the party or if the other party is not going to comply with the resolution. Therefore, ensuring that parties that enter into an online dispute resolution process is a challenge for anyone attempting to apply ODR to cross-border e-commerce. Because in the traditional online dispute resolution process, compliance is less of an issue because parties are bound by relevant laws that are applicable, and the laws of many developed nations generally look at dispute resolutions that are entered into before the transaction. So it becomes a real challenge to design a system whose outcome is binding on all parties. So ladies and gentlemen, I think I have come to the concluding remarks of my paper. And in conclusion, ascertaining the applicable law and jurisdiction may well impact significantly upon the parties' respective rights and the approach that any party may wish to take to a dispute. So disputes arising from e-commerce are usually difficult to deal with, and that is especially true for disputes arising from cross-border and low-value e-commerce transactions. Therefore, it is necessary to have an appropriate resolution mechanism to handle and resolve these disputes in this era of the digital world. And it should be noted that ODR would not abolish the traditional court system, but would merely be the default system. In addition, better containment and avoidance of disputes of ODR at the stage of ODR will greatly reduce the number of disputes that need to be resolved by judges, and this can be achieved through ODR because it extends the scope from beyond dispute resolution. So therefore, traditional courts will, as a result, be restricted to those claims that are otherwise unavoidable. And last but not least, given the complexity and uniqueness of e-commerce, multi-jurisdictional transactions, any party finding itself involved in a cross-border contractual dispute would be well advised to take advice at an early stage so that it can ascertain how their rights and obligations may be affected by the laws which apply and the jurisdiction in which any dispute would be determined. So it would be certainly be unwise to assume that the rules which apply in a party's own jurisdiction will necessarily be the same elsewhere, because contractual terms between the parties would still prevail. I think that's all from me, and thank you so much for listening, and I'm happy to entertain and to respond to any questions, if any. Over to you, Dr. Imam. Thank you so much.
Yeah. Thank you very much. That's Professor Hafini Saripan. Very interesting presentations. I think she has already made a concluding remark about her presentations, but I have some noted about these presentations. she said about the e-commerce dispute, high in volume but low in transaction value. And ODR, this is initiative by Untitled Model Law, effectiveness, fairness, and accountability, and transparency also. But to settlement according to Untitled Model Law, make negotiations on facilitative settlement and award. Yeah. And then according to the ASEAN initiative, also according to ASEAN Economic Community, also a blueprint, e-commerce 2025. And then also she mentioned also compare with the European Union with using the single point of entry, and also compare with the China is already advanced. They have a 4 platform to handle the ODR, yeah, online dispute resolutions. I think Professor Tini Seripan, you still with us? Can you wait until the next speaker to join with us to get the question and answer?
I leave it to you, Doctor. I can,
okay, then, thank you.
answer now.
Thank you.
Because yeah.
We happy if you are still with us. Yeah. Please we listen to another speaker first. Yeah. Is it okay?
Yeah, sure. I'll be happy to join. Yeah.
Thank you very much. Okay. Let me call the next speaker is Camila Kasim. Camila, are you already in the Zoom meeting? Camila? Camila Kasim, can you hear me? Camila? Not yet? Can I call Professor Rimanto? Professor
Yes,
Rimanto?
Dr. Imam, yes.
Baik. Allow me to read your CV first before you deliver the speech, Pak.
Okay, sure, please do.
Professor Hikmahanto Juwana, SH, LLM, PhD. He studied at the Faculty of Law, Universitas Indonesia. Got a bachelor degree, and then in 1992 also Keio University, Japan. Got a LLM degree, and then the PhD degree will got from Nottingham University, December 1997. Pak Professor Hikmahanto Juwana is a lot of experience helping and supporting the government activities. Yeah, also as a special assistant, a lot of activities, and then also as let me see, since as a lawyer also starting in OCK Legis office, and then Faculty of Law of University of Indonesia until as the Dean of Faculty of Law. A lot of activities in the law firm also, Lubis Gani Susruwijoyo, also AJ Ruru, Ibu Ruru, yeah. Also Menko Perekonomian, Menko. There's a lot of activities, Professor Hikmahanto Juwana. I think we already know about him, and then not further delay, I think we better ask him to deliver his presentation today. Probably not more than 30 minutes, Pak. Please, I'll let the time for you.
Sure, thank you very much, Dr. Imam. I hope that I'm not going to use all of my 30 minutes. Here, I'm going to discuss with all of you on issues of transnational education, especially on the legal education, which I'm familiar with because I was a dean at Faculty of Law, University of Indonesia, Universitas Indonesia, and currently I'm the rector of Universitas Jenderal Ahmad Yani. So I think there should be a collaboration between universities around the world so that the graduates can practice not only in their particular country, but also in other jurisdictions. This is so because, as you all know, when we are discussing about law, there's no universal thing about law, because law has something to do with sovereignty. Yes, there are principles that is common from various jurisdictions. Nonetheless, a lot of them are different from one country to another. And this is where you need to have a license to become or to practice law in certain jurisdiction. However, in many jurisdictions, you are not prohibited from practicing law, even though you are not the national of that jurisdiction. But of course, you need to understand that jurisdiction law so that you can practice the law with confidence. As we all know that in Indonesia, we have a lot of foreign practitioners practicing their own jurisdiction here in Indonesia. And of course, assisting Indonesian clients if they have transactions around the world. But I know many of my students have practiced also in other jurisdictions. Most notable is in Singapore, and some they're practicing in Australia. The question now is how we, the universities, can facilitate the students who are desiring not only that they can practice in Indonesia, but they practice also in other jurisdictions. And of course, the parents of the students would be willing to invest in their children's education if there are a benefit that they can take from their children's education. So first of all, are there demands? Yes, to me in Indonesia, there's a demand for postgraduate, of course, then undergraduate. Nowadays, a lot of my law students are pursuing their postgraduate outside Indonesia. Whereas for undergraduate, the problem is because, as I mentioned, that they need to apply at the local law schools or local faculty of law. And after that, they need to apply for their license. And most of my undergraduate students who do law outside Indonesia, they will finish and they will have a certificate on their undergraduate. However, they are not pursuing their professional training as a lawyer, which I think in many jurisdictions this is very important. In Indonesia, the professional training is referred to as, if you want to become a practicing lawyer, it's referred to as PKPA, Pendidikan Khusus Profesi Advokat. But if you want to become a judge, there is a professional training called the Calon Hakim. Or if you want to be a prosecutor, there's this training on P3J, Pendidikan Pelatihan Jaksa. And if you want to become a notary, you have to enter into the master degree of the notary, Magister Kenotariatan. So sorry, this is so the demand, for other studies such as engineering or econs or business, it is great, but engineering, econs is more universal. I mean, if you study engineering, civil engineering in Indonesia, you may probably end up, studying the same in other countries. Yeah. But if you are studying law, that is going to be different, because if you study law, unless you study only international law, there's a similarity if you study international law. But if you study, local law, that's not going. That is different. Okay. Okay. Demand is driven by long-term investment by parents or companies, law firms. They would want to have, some lawyers who are able to practice in quote unquote more than one jurisdiction. Yeah. And then undergraduates in Indonesia who wants to work outside Indonesia. Undergraduate who wants to perfect their English besides furthering his or her knowledge. That's also important in Indonesia. And also undergraduate who wants to further his or her careers in Indonesia. So to me, opportunities, yeah, the excellent quality of other universities around the world, they wanted to pursue there. Yeah. For example, most of my graduates, they want to study in the US, to go to, say, Harvard. They get the degree, and afterwards they will try to try the bar exam in New York, and hopefully that they can pass the exam. Or some of them may want to go to Oxford, yeah, to study their postgrad.
Domain fx dan gx.
Sorry. Okay. Okay. But of course, we need to push our students to also study in various countries, like in Malaysia, yeah, in Singapore. When I was the dean at Universitas Indonesia, I wanted to have my students to pursue their legal studies, not only in Indonesia, but also in Singapore. So at that time, I still remember that I would want to cooperate with National University of Singapore, so that within 5 years, a certain student can have their 2 degrees, law in Indonesia, SH, and then the LLB from Singapore. So by that, the students can apply for a license not only in Indonesia, but also in Singapore. So they can practice in these 2 jurisdictions. Of course, if you do arbitration, you don't need to have a certain license to be able to practice in arbitration, which is good. But if you go to a court, then you need to have a qualification as a lawyer in that jurisdiction. Yeah. So if my students go to Singapore, and they can go to Malaysia, go to Thailand, since we're going to have this ASEAN Economic Community, I think it is good for them to be able to study not only law of in the jurisdiction, but also to study the local language. Okay. Okay, and as you know, many Indonesians have graduated from various foreign universities. But the challenges, yeah, competition with Indonesian universities, since looking at the same market. I have the idea of having a dual degree at Universitas Jenderal Ahmad Yani, so that a person can study law and at the same time, say, studying engineering, so that they can have later on specialization on construction law, for example. And they can study law, but also study accounting, so that they will have a specialization on M&E. Of course, our education is different from, say, in the US, whereas in the US, you need to have an undergraduate degree first, other than law, and to be able to enter to a law school, because law school in the US is a postgraduate. By that, a person can have, say, knowledge on engineering, on pharmaceutical, for example, and what else? Politics, and then they will then pursue law. So then when they graduated from the law school, they will have a certain specialization. But other challenges is decreasing purchasing power because of the pandemic, COVID-19. Yeah, but hopefully the world's economy will recover soon, so that the decreasing purchasing power is no longer there. And also how to implement cooperation instead of competition between university in Indonesia, and other universities around the world. This is also very important. Next is what type of partnership. For postgraduate master, dual degree, Yeah, one semester in Indonesia and say one semester in the UK. Yeah, and the two universities will issue a degree, but of course they have to pay tuition fee, the local tuition fee. They can do that, yeah, or one semester in UK as an undergraduate student, but returning to Indonesia to finish up with the degree, and then return to UK for another semester to be awarded a master degree. So this is a type of partnership between universities. PhD, probably you've heard about the sandwich program, we can do that. But this is most important for the undergraduate, where 3 years in Indonesia. Nowadays, many universities in Indonesia have what we refer to as an international class, which is everything conducted in English. So that and then the last year they can take course which will be recognized as a credit in Indonesian universities. So they will take course outside Indonesia and then recognized as a credit in Indonesian universities. But also this is what I'm hoping is that we can have a cooperation where students, undergraduates studying law in Indonesia and at the same time studying law in Singapore or in Malaysia. So when they finish, they will have 2 degrees from both universities. Even though it is law, but it is a requirement that you need to have a law degree from local universities to be able to qualify as a lawyer in a certain jurisdiction. So, okay, this is the issue that may be encountered, recognition of subjects between 2 universities, financial concern, adaptability of students, the infrastructure in Indonesia is not the same thing, it's not the same as other countries probably. The learning culture is also different, and visa. Nowadays, you know, depending on which government of a visa, but sometimes they are very easy to get a visa to study abroad. So this is, well, lastly, the need for government involvement. I think the government needs to be involved, especially this is in Indonesia. Regulation-wise, they need to be supported. And then the government also can support in the form of scholarship for student and faculty members. And hopefully, the government do not discriminate between the public and private universities. Because for UPN, they're very lucky because previously it was a private university. That's not the important issue, whether you are public or private university. As long as the government do not discriminate between the universities, I think the universities in Indonesia can excel. So with that, I think I will end my presentation. I hope, can I have another 2 minutes, Dr. Imam? So I can,
yes, please, yes, please.
Yeah. No, I wanted to promote my university. If
please, can.
Okay. Wait, hang on. Just 2 minutes. My current university, University Jenderal Ahmad Yani, is owned by the Indonesian military.
Saya ingin, Prof, Unjani di Indonesia harus menjadi level postgraduate school di Amerika.
Unjani sudah saatnya untuk take off, sudah saatnya untuk maju. Kita harus bisa mengejar ketertinggalan kita. Makanya ICT ini kita bangun, kita paksakan. Tapi pada saat yang bersamaan memang kita pun harus memperbaiki fisik Unjani, fisik.
Okay, so our university is owned by Indonesian Army, not the military, because the Indonesian military, they have various universities under their, Army, Navy, and Air Force. So thank you very much, Dr. Imam. Thank you, and then I will entertain any question if there are from the floor. Thank you very much.
You're welcome. Thank you very much, Professor Hikmawanto Juwana. Prof, your presentation is very interesting about the transnational educations, yeah, starting from the bachelor degree, and so probably the what we call it the freedom to read, freedom to learn, not only in Indonesia, also in abroad. So this will be changing a lot of capacity and capability of our students study in Indonesia, also in abroad. And secondly, you also make the dual degree also for master degree in Indonesia and also in abroad. And the third one is for PhD or sandwich program. This is very interesting to all of us. And then you are concerning about the educations. And I'm really sorry not to mention you as professor, a rector of Unjan, Hikmahanto. And then we learn from your campus. Your campus is very high tech, I think, yeah, Pak. If this is already built or not, Pak Hikmahanto? If already built, we'll visit your campus soon.
It's going to be built starting next year. So, and it will take about like 4 years time, but it has been determined by the chief of the army.
I see. Excellent. We pray for you, and because it's very interesting and high tech building, I think. Yeah. Okay. Now for the day, we welcome the next speaker. Pak, can you wait for us to discuss until the discussion? Okay. Thank you.
Hi, Pak Imam. This is Camila.
Hi, Camila. Okay, now Camila already here. Please, Camila, before you present your presentation, allow me to read your CV, right? Just brief CV. Actually, Camila Kasim is got a LLB and LLM in University of Malaya, Malaysia. Actually, a lot of students graduate with honors from Malaysia. They work in Singapore. So they study in Malaysia, they make money in Singapore. They know the conversion rate of the value of money, yeah. And then actually Camila is practice includes contentious and non-contentious matters relating to infrastructure projects in Asia. She practices as a dispute resolution lawyer and has been involved in various dispute cases with a focus on large complex engineering and energy project. Yeah. Camila also ranked as a leading individual for project and energy, real estate, and construction in the Legal 500 Asia Pacific, and was described as a commercial strategic litigator and who understands construction industry norms and gets straight to the point. She also recognized as a highly regarded lawyer for energy, transport, oil and gas and mining in IFLR 10,000, 1000, and is noted for being knowledgeable, experienced, and enthusiastic. She is also listed in the spotlight table for projects, infrastructure, and energy in chambers of Asia Pacific. And in Asia Pacific, she is lauded as brilliant and formidable by numerous market commentators for her extensive experience in the energy and infrastructure sectors. I think Camila have a lot of experience. I think you can deliver your presentation, Camila, within 15 or 20 minutes or half an hour maximum, please.
Okay. Do you think you can allow me to share documents?
Yes, can do. I think, please.
I'm not very sure. Can you see? I don't think I can, because I'm trying to.
Yes. Moment. sorry, not mentioned. Camila Kasim now is working for the biggest law firm in Singapore, Allen Hill law firm. Yeah, previously also the second biggest law firm also in Singapore. Yeah, yeah.
Yeah, Pak
Yes.
Imam.
Okay.
I'm
Yes,
trying
please. Can you
to
share
share
the
my slide presentation.
Yes,
I'm
please.
trying to share my, but you have to let me.
Allow. Yeah.
Yeah. Have you?
The committee already allowed you.
Okay.
Yeah. The committee allowed
hang
you.
on, yeah.
Yeah.
All right. Hang on. Just 1 minute. Can you see the?
Yes. Yeah. Okay. Yes, we got it. International arbitration. Yeah.
Yes. Okay. So.
Yes.
Thank you very much, Pak Imam, for inviting me. Last minute, I really thought the talk will be tomorrow because actually I scheduled it in my diary tomorrow, actually. Lucky I'm at home. I'm so sorry about the miscommunication, but I'm here now. Thank you very much for the very, very kind introduction just now. Actually, as far as chambers and partners, I'm no longer in spotlight table, but actually band 1, the only 2 lawyers rank for energy project infrastructure. Project infrastructure, oil and gas is highly specialized. Okay, because it is highly specialized, not many lawyers, not many judges, all right, understand the industry like oil and gas. That's why if there are any disputes, the industry normally do not go to court. Because, all right, for the typical commercial judges in court to understand the jargons, peculiarity in project for example, all right, is going to specialist. If I were to talk about variation, if I were to mention the word FIDIC, for example, all right, the industry would understand. Most probably, if you go to a domestic court, chances are the judges would have not heard of those words. So you have to teach him and or her, and it takes like 2 or 3 weeks sometimes teaching, all right, the industry, the contract, all that. This is one of the reason for arbitration, other than the fact that if I were to invest in Indonesia, I don't want to go to Indonesian court. If I am from Indonesia going to Malaysia, I don't understand Malaysian court, Malaysian legal system, all right? Therefore, this arbitration is being introduced because I invest, I throw money, and it's a lot of money to do things, for example, in Indonesia, in Singapore, in Laos, in Cambodia, all right? So we want to have a dispute. Sudah gaduh ya? In Indonesian, gaduh, apa dia Pak Imam?
Yeah.
Sengketa.
Yes, sengketa.
Ya, sudah bersengketa, nggak mau pergi ke mahkamah. In Indonesia, mahkamah is mahkamah ya, Pak Imam? Yeah. Okay. So we want to go to independent court, mahkamah, yang enggak ada kena-mengena dengan negara di mana investment itu diperlakukan ya. So basically this is international arbitration. Timbang Tara ya. How many of you here knows what is the meaning of arbitration? How many have we?
I think mostly the participants already knows about the arbitrations because I teach them. I teach them arbitration.
Okay, perhaps one or two may want to tell me what is it? See whether how effective Pak Imam's lesson.
Yes,
please. One or two participant, you know, if you could tell me what is arbitration?
Is there any participant, please?
No, nobody. I am Malay from Malaysia, so I understand Indonesian quite well. So if you're not comfortable speaking English, bisa sahaja berbahasa ya.
Ada, please. Is there any question or answer? Sorry, is there any can answer this question?
Apa itu arbitration?
Halo?
Enggak ada ya?
Halo?
I can hear you, Pak Imam.
Yeah. Is there any participant? Oh, you are right that so many government officers do not understand or misunderstand about arbitration. That's all.
Okay. Arbitrasi atau timbang tara is actually an agreement between the parties to a contract, how they want to resolve their dispute. Sometimes you heard of this word, alternative dispute resolution. Resolution, it means a lot. Alternative dispute resolution. Alternative mean yang lain daripada pergi mahkamah ya. Kamu boleh pilih cara lain untuk menyelesaikan sengketa. That's all it means. Dispute resolution, alternative dispute resolution. Resolution, kamu pergi ke mahkamah, bila mahkamah bilang keputusannya ini, sudah ada satu resolution. Yang kalah kemungkinan kena bayar, yang menang dibayar. Jadi arbitration adalah antara alternative dispute resolution. Di antara penyelesaian sengketa yang disetujui oleh kedua-dua parti yang berkontrak. Misalnya, saya berkontrak untuk membina jalan raya expressway di Indonesia. Kontrak itu ada satu kontrak. Okay, saya mesti menyelesaikan jalan raya itu ataupun expressway dalam jangka masa. Sekiranya ada persengketaan mengenai kontrak jalan tersebut, ada satu lagi kontrak di dalam kontrak itu. Kontraknya ialah sekiranya ada persengketaan di dalam kontrak jalan.
Excuse me, Camila.
Yeah.
Speak in English better.
Okay.
Try understand.
All right. If there is any dispute relating to anything in respect of the expressway contract, we will not go to court. We will go to arbitration. So this is another forum that we are going to go to resolve our disputes. So this is arbitration. So basically an arbitration is a contract, an agreement in itself. All right. In that contract, you agree, all right, where the arbitration is going to be, how many judges, i.e. arbitrator, is going to listen to the dispute, all right? What is the law governing the arbitration, or the seat of arbitration, okay, and what is the language for that arbitration. So this is very fundamental. Okay, don't talk about international arbitration, don't talk about any other thing about arbitration until you understand the fundamental. Basically, it is an agreement between the parties not to go to the conventional dispute resolution forum, i.e. litigation, or to go to the domestic courts, whether in Indonesia, whether in Malaysia, or anywhere in the world. Just like any agreement, just like any contract, all right, if you look at this, the arbitration agreement, remember, I keep mentioning is agreement, gives and defines the scope of arbitral tribunal's power to decide on the dispute. So the arbitral tribunal may be one person, maybe 3 persons. It's just like a court, and it can decide on the dispute. Okay, so just like any agreement, it must be very clear, because under most jurisdiction, ambiguous agreement which lead to uncertainty is void because you don't know what it means. So the requirements of an arbitration agreement, just like any agreement, all right, it must be in writing. It must clearly refer disputes to arbitration. All right, it must be capable of being performed. Everybody understand that, you know, if we have any dispute, we will refer to this arbitration. And it must be clear where the arbitration. Sometimes people just cut and paste. They don't even know what they're writing. They just take, you know, a precedent from somewhere and just chuck it in the agreement. Okay, so it must state the appointment of the tribunal. It can be in the same contract. I was talking about the contract, the expressway contract just now. It can be put it, you know, it can be one of the clauses, one of the provision in the expressway contract, or it can be, you know, put elsewhere in a letter, you know, for as long as it has the effect to enforce. It's a very, very simple agreement. All right, this is an ad hoc. Ad hoc means it is not referred to any institution that manage arbitration. All right, in Indonesia, the institution that govern arbitration is BANI. I'm sure everybody has heard of BANI, okay? In Singapore, it is called Singapore International Arbitration Center, SIAC. In Malaysia, it is called Asian Arbitration International Center, AIAC. In Hong Kong, it is called Hong Kong International Arbitration Center, London International Arbitration, AAA, this is in America. So these are the institutions. So every time you see the word ad hoc, it means there is no institution. Okay, there is no ICC, there is no SIAC, there is no ICC. So if you can have a look at the, you know, the agreement in writing, any controversy or claim arising out or in connection with this agreement refers to, for example, just now, the expressway agreement shall be settled by arbitration. It's very, very clear. You intend to refer any dispute in this agreement just now, all right, that you enter. This is another agreement. This agreement refers to the underlying agreement, the expressway agreement. The place of arbitration shall be, let's say, Singapore. All right. Place of arbitration doesn't have any meaning except that a place. If you put a seat, the seat of arbitration, it means, all right, the governing law of this arbitration agreement. If you put Singapore, it'll become Singapore. Okay, so basically, this agreement, this expressway agreement can be governed by Indonesian law, but the arbitration agreement, which is a different agreement, all right, if you put a seat here, the seat or the law of arbitration shall be Singapore. So you are going to have Indonesian law governing the expressway agreement and Singapore governing the arbitration agreement. Okay, so you need to be clear as well. What sort of language do you want to use? The language to be used shall be English. So another agreement. One agreement, all dispute shall be settled by arbitration. Second agreement, the place or seat arbitration shall be Malaysia, Singapore, or New York or Paris. The language shall be English. The arbitral tribunal shall consist a single arbitrator, can be 3 arbitrators, and you have to agree on how the appointment to be made. So this is ad hoc. So we'll see. I talked about the institution just now. This is institutional arbitration. I have mentioned just now, there is LCIA, London International Arbitration. So what they do, this institution, they just manage arbitration. Sometimes they manage experts, but basically they don't do anything else. You know, it's almost like a court, but it is a profit. You want to make profit, you want to make money, because once I register my arbitration, whether here or in Stockholm or in Singapore, used to be Kuala Lumpur Regional Center. Now it is called AIAC Asian. It has been changed the name. So I have to pay, here I have to pay about 500 Sing. ICC, I have to pay about 2,400 fee just to register. And throughout, let's say if your claim, okay, the dispute costs about, 100 million US. So there is a percentage that you have to pay to the institution. So it looks like this, yeah. I mentioned AAA just now. This is how it looks like. This is Stockholm. All right, this is Hong Kong. This CTAC, this one is basically mainland China, even though it is in Hong Kong. All right, we have Hong Kong. It's quite very mature, even earlier than SIAC, even though I think SIAC now has overtaken Hong Kong International, being one of the most effective center. We are talking about effective. Basically, it's easy to deal with because these are service provider. Okay, they must be fast. They must be acutely aware of the need of the user. Whoever that is in dispute want to use. And we have this London because right now it's becoming very, very expensive to go to London. That's why people go to SIAC, all right? AIAC as well in Malaysia. And ICC is one of the oldest one, International Court of Arbitration, but it is very, very expensive. Okay, the good thing about having this institution, all right, the tribunal, all the arbitrators that is sitting as a judge has this institution looking over them, all right? So they cannot sit and not give the award for 3 years, for 4 years sometimes. In India, there's one arbitration that went on for about 12 years because, all right, nobody's looking after the proceeding because basically it's ad hoc. Parties agree to the regulation and how the proceeding is going to be done. But if you go to SIAC will probably blacklist it any arbitrator that does not do his work properly. So far clear?
Yes, clear. Yeah.
Yeah. So, so each institution will have its own rules. Rules is just like, I'm not very sure because I've never been to Indonesian court, but they will be in Malaysia, for example, or in Singapore, there is such a thing called high court rules. The rules that tell you how to appoint arbitrator, when to file, how to file notice of arbitration, how to file the response to notice of arbitration. All right. Once the tribunal appoints, when to file the statement of defense. For the non-lawyers right now, you may not be able to understand this until you go to court, because you have to file join the okay. And this is the advantages between ad hoc and institutional arbitration. Okay, advantages, all right, there is availability of pre-established. So basically, when you advise later on, when you become a lawyer, or if you're already a lawyer, or if you are in-house counsel at the moment, all right, when you want to use arbitration, you must be really clear why you want to use arbitration. Okay? And once you have decided you don't want to go to court, you want to go for arbitration, you have to be very clear whether you want to go for ad hoc or you want to go for institutional arbitration. If you choose ad hoc, why you choose ad hoc? You must understand, because it is an agreement. Okay, do not ever cut and paste any arbitration clause, all right, just for the heck of it without really understanding. Okay, so if you choose institutions, arbitral institution, all right, you must be very clear why you choose a certain institution. If you choose SIAC, why you choose SIAC? Why not Hong Kong? Why not AIAC? So all this, all right, you have to be clear in your mind, all right? Don't just cut and paste, because it can be not very good. So the advantages of, I will let you know, I will, show, some of the very bad drafting where, sometimes you get jammed up, you can't go to arbitration because the agreement is not a good agreement. I was talking about uncertainty, ambiguity just now. But right now we'll go to whether or not you want to go for ad hoc, you want to go for institutional arbitration. So the advantages, there is a pre-established rules and procedures. You don't have to do it yourself. Ad hoc, you have to write the rules yourself, okay? Or otherwise you have to go to ancestral. So that's another matter. The best thing for you to do, if you want to go for arbitration, the drafting of arbitration, you talk to arbitration lawyer, you talk to people like me, because we know arbitration in and out, okay? At least spend a bit of money to try and understand, rather than pay unnecessary money later on for, not drafting your arbitration agreement properly. So you have a pre-established rules, you have administrative assistant from the institution. Remember, I said just now ad hoc, all right? The arbitrator is actually God. Okay, you can't do much. You can't really force him to come up with decision, because you go for any dispute resolution, you go to court. The most important thing for you is actually the award. You want the award, you want the judgment. And like Singapore, it has a list of qualified arbitrators and established format with proven record. The disadvantage is administrative fees. You have to pay for the facilities, bureaucracy, and parties may be required to respond within unrealistic time frames. But to me, it's good. At least, file within 30 days, file within 45 days, so everybody is very, very clear what they should and shouldn't do. So here again, ad hoc procedure, very, very flexible, not expensive. The only person that you need to pay are lawyers and the arbitrator. You don't have to pay any institution. Parties are more controlled, but not realistic sometimes. If you ask me, all right, I would not advise on ad hoc arbitration at all. Spend a bit of money, especially when you're the dispute that I normally typically involved with, not less than 50 million US. So you don't want to scheme on, money, all right, unnecessarily. So this is how the arbitration agreement, this is already drafted by, if you want to go to SIAC, the SIAC model agreement is already there. You do not try and redraft it and reinvent. It's already here, okay? You go to the website of SIAC, you look for the model clause or model agreement, you will find this. So it is more or less the same. Any dispute arising, blah, 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 you will go to Singapore International Arbitration. You are going to use the rules, just now I said, of SIAC. The tribunal shall consist, so you put 1 or 3. The language of arbitration shall be whatever it is, either 1 or either 3. It has to be odd, yeah. And if you are a non-domestic, if you're from Indonesia, you're from India, you may want to put the seat. Remember just now, the word seat is very, very important. It's not just a place. It means the law that governs this agreement. Okay, so here, this is AIAC now. It's more or less the same thing. You have to put how many. This is Hong Kong. Okay, the law of, you see, the agreement is the same. Okay, to go, instead of Singapore, now you go to Hong Kong. The law and the seat, Hong Kong, number of arbitrators, and shall be conducted. The language again. The same thing for LCIA, London, the same, okay? So basically, the place of arbitration, seat, the rules governing, just now SIAC rule, AIAC rule, LCIA rules, AAA rules, and the language. I'm not going to look into all this. I'm just going to look for bad arbitration agreement. Okay, we'll sort of here. Okay, this is the agreement that people try to draft. Who is not arbitration lawyer, who has never gone for arbitration. Okay, we call it okay. All dispute arising in connection with present agreement shall be submitted in the first instance to arbitration. I have no idea what's the meaning of the first instance. Should be, shall be submitted to arbitration. Enough. The arbitration shall be a well-known chambers of commerce. What is a well-known chambers of commerce? We have millions of chambers of commerce. So this is where we call ambiguity, uncertainty. Which chamber of commerce are you talking about? Designated by mutual agreement of the parties. Okay. When you talk about mutual agreement, it means an agreement to agree. It is unenforceable because when we agree to agree, that's all, the agreement is agree to agree. It does not force you to agree. So the entire thing here, all right, you may be stuck. Your intention to go to court may not happen because the entire thing is void for us. Uncertainty, one, because we don't know what's this. Nobody knows what's this. I don't know. You can ask 1,000 people, like the International Chambers of Commerce. Even here, you don't know which one. okay, designated by mutual agreement. What if parties don't agree? The reason why party want to go for arbitration because they are now in dispute. When people are in dispute, you don't agree on anything. Okay, so here.
Excuse me, Camila.
Yeah.
Time's 2 minutes. Yeah, 2 minutes left.
Okay, I am more or less done. All right, I'm just talking about issues that could arise if you do not articulate or if you do not draft your arbitration agreement carefully. Yeah, I'm done. If there's any issue, arbitration proceedings just like going to court. Yes.
Excellent. Thank you very much. Can you stop share screen, Camila, please? Okay, I think Camila already present about the arbitrations procedure, yeah, about the seat of arbitrations, about the pros and cons and with litigations, also the advantages of arbitration compared to litigations. Yeah, I think you already noticed about this. Please, I invite the participant to raise the question to Ibu Professor Hartini Saripan. I call Professor Dr. Haja Umi. Haja Umi, you want to speak? Haja Umi. Haja Umi. Are you there? If not Haja Umi, Dr. Haja Teti Indrawati. Or I can read your question in. Aman. This is question to Associate Professor Hartini Saripan. E-commerce is difficult to decide. Who will take responsibility where the problems comes up, and a lot of supplier or seller in the marketplace. The question is who the real person or company will take responsibility for this problem, because of when we got accepted the product in the market share will be sorry, because I try to translate in Indonesia, because probably not sending or problem with the product.
You can try in Indonesia first. See?
Yeah, what is the Malay?
I am very, very sorry because e-commerce is not my
no, for Camila. This is for Professor Hartini Saripan, Camila.
Oh, okay.
This is in panel discussion with you and Professor Saripan and also Professor Rimahanto. And then the question is raised to Professor Hartini Saripan, yeah? Just wait together with us.
Okay. This is not to me, yeah? Okay.
Yeah, not to me. Yeah, okay, moment. And then in Malaysia, is there any ODR institutions and have any rules about this, how to handle this situation like this? Yeah, please. Professor Hartini Saripan, yeah.
Thank you so much, Dr. Imam. You can hear me, right?
Yes, I can hear you. Please.
All right. Thank you, Dr. Haja Umi, for your question. I think you were asking me about the ODR legal framework in Malaysia and the challenges when it comes to rights and liabilities of the consumers. Now, as I mentioned earlier, since most of these cross-border e-commerce disputes involving consumers, the nature of the transactions are pretty much high volume with low value transaction, bringing these cases to courts, may be very, very challenging, and that's why it will take longer, not to mention, the cost. And that's the reason why most of the countries have actually advocated online dispute resolutions as the one of the best mechanisms in terms of effectiveness, in terms of cost, to deal with consumer disputes, particularly when we talk about cross-border e-commerce disputes. And when it comes to the legal framework specifically on ODR in Malaysia, truth be told, at the moment, what the legal framework that we have, the statutes that we have are basically Arbitration Act 2005. We also have Mediation Act 2012, and then we have Construction Industry Payment and Adjudication Act CIPA 2012. This is specifically for construction. Now, at the moment, these statutes do not really prohibit the use of technology in any of the ADR processes. So because of that, we are advocating the use of technology in any of the ADR processes. For example, if I could actually share with you, in adjudication, we have the online platforms where claimants would actually submit, their claims and their documents, and everything would actually be done online, except when the session is taken place. And then we also have the teleconferencing session, and in certain cases, arbitrators, adjudicators are actually foreign neutral third parties that we appoint from different jurisdiction. So in a way, we are advocating this ODR process. However, at the moment, we don't really we have yet to have a formal framework, a formal framework for specifically for ODR. But the initiatives towards ODR are actually in place. Okay, Dr. Imam. I hope.
Yeah.
I hope that answers your question, Dr. Umi.
Yes, I hope so. Thank you. Thank you very much, Associate Professor Ratini Sarifan. Yeah. And the next question to Professor Hikmahanto Juwana, asking from Iwan Error, asking about the moment. Why Indonesian government usually use the foreign law firm for their legal problem? Any problem to Indonesian lawyers or Indonesian law school? Professor Hikmahanto, silakan.
Well, yes. Well, this is very interesting questions. Probably there are three reasons. First of all, the government does not have a great confidence on Indonesian firms because the Indonesian firms are more focusing on domestic issues rather than international issues. But nowadays, a lot of Indonesian firms are expanding themselves so that they can handle arbitration cases, not only in Indonesia, but say in Singapore International Arbitration Center, or in Malaysia, or even in Hong Kong. But not too many of them, I have to say. And it is because if you do an arbitration case in various jurisdictions or in international arbitration, there are some procedures that you need to understand and to know. For example, a case of an arbitration tried in Singapore may take some months, even a year. Yeah, and everything has to be there. Or for example, if you ask for an expert, they need to convey their authorities saying that meaning laws and regulations, court decision, even textbook. Yeah, every word has to be there should be an authority, which is uncommon for Indonesian lawyers. Usually Indonesian lawyers, if they ask an expert to say something, the court will take it as is, whatever the expert is saying, but not in arbitration, for example, in Singapore or in other places, in other jurisdictions. So the confidence of the government is not there. Secondly, the government would want to see a firm that have experience in arbitration. And this is a problem that we've encountered because not too many Indonesian firms have this exposure of going to foreign arbitration. Nonetheless, nowadays, Indonesian firms are collaborating with foreign firms so that they will have exposure to handle arbitration cases. And I have students who graduated 10 years ago who have now set up their own firm and specializing in arbitration, not only in Indonesia, but in other jurisdictions. Thirdly, the government, this is something to do with whether Indonesian firms have a good command of English, because even our own government does not trust that our lawyers have good command of English. So they are afraid that if the lawyers have some trouble in expressing themselves in English, then they might not win a case. So these are the, I think, main reasons why the government does not trust in Indonesian firms. But again, I think the government need to start to trust Indonesian firms, to trust to Indonesian lawyers, so that they will have a good exposure in dealing with international dispute, which end up in arbitration, so that the level of lawyers in Indonesia can be heightened in like other lawyers in other countries. And if it is not the government, who else who's going to trust the Indonesian lawyers? Once the government trusts the Indonesian lawyers, I think many private enterprises, private businesses, they will trust also Indonesian lawyers. And as I mentioned, you know, for us, the lawyers, we cannot sit and then wait for the government to trust us. But as I mentioned, we need to broaden our students, law students, by having them doing exchange students, or as I mentioned, doing a dual degree with other universities abroad, so that they will have the same level as their peer in other jurisdictions. Thank you.
You are welcome, Mr. Professor Hikmahanto Juwana. Thank you for your answer. And the next question to Ms. Kamila Kasim from Sandi Ersa Arasid. Yeah. I would like to ask more about international arbitration. Do you think settling a case in international arbitration is really worth it, considering the fact that our domestic court and Supreme Court in Indonesia are able to cancel international arbitration award? Thank you. Please, Kamila Kasim, your answer.
Okay. The issue with Indonesian court is not the issue with arbitration. It is like the Polian courts rather than. But you know, going for international, the one of the fundamental reason why people go for international arbitration or arbitration, because of the New York Convention. Okay, basically, all right, there are about 100 series of the New York Convention. So basically, when you have an award, or if you have a judgment, unless and until you can enforce the award and the judgment, it's just a paper judgment. It's not worth, all right? With arbitral award, all right, and if you are the signatories, and we have about 150, the latest one being Myanmar, you can actually enforce this award in New Zealand. When I was in Jones Day, we actually, okay, managed to ground one of your Garuda airplane. Because this is, you know, arbitration again, Indonesian government, but that was a long time ago. So basically, we managed to do this, all right, in Switzerland. The award was issued in Paris, really versatile, you know, and flexible. All right, if I have a judgment in Malaysian court, for example, I don't have that many countries that I can do it reciprocally. All right, most probably Hong Kong, Singapore, that's it. All right, you have a judgment in Indonesia, you can only enforce it in Indonesia if you go to Indonesian court. If you go to Singapore court, very, very limited circumstances where you can enforce it, elsewhere. But with international arbitration, you secure an award other than India, Indonesia, chances are the domestic court will accept unless there is a public policy issues, fraudulent, all that, okay? If you go for a good institution, for example, your arbitral award is from LCIA, from SIAC, okay? You go to Malaysia, you register it, chances are the Malaysian court will honor this award and you can, enforce it, all right? The issue in Indonesia, the issue with your Supreme Court cancelling the international arbitration has nothing to do with the has nothing to do with the New York Convention, has nothing to do with the beauty of international arbitration, but it is really a policy in Indonesia, which I'm not very sure why. But this is one of the reasons why, people are a bit nervous, all right, doing, investment in Indonesia. You don't really go for a proper dispute resolution. In Indonesia, all right, you do other things to resolve your issues, okay, because of this. And I think one day, the Indonesian court Supreme Court, especially Supreme Court, need to sit down and ask themselves, all right, why the need to cancel international arbitration verdict, okay? For example, from SIAC, I have done arbitration since 1995, okay? A long time ago. And in Singapore, everything is clean, everything is transparent. Okay, chances are when you lose and when you win, all right, is on merits. It's not because of other issues. Okay, even if you go for AIAC, all right, when we appoint arbitrator, we must make sure that these are the people that, if we go for oil and gas, the judges or the lawyers, all right, have done or understand the industry. I don't advise on shipping because I've never done shipping. When somebody mentioned e-commerce, I thought, the question was directed to me. I will not try and be clever and advise about e-commerce because I've never done it before. I probably know, I can read, but it's not something I can do. But when it comes to power purchase agreement in Malaysia, for example, or a power purchase agreement in Laos, in Cambodia, for example, it's just like this, I could understand. I could even remember the clauses, the provision, because this is something that I do on a daily basis, okay? So I don't think the Supreme Court has this ability, with respect, because, lawyers are just like doctors. Some of us are really specialists. So if you want to give birth, all right, you don't just go to you go to a specialist, and to answer the question about why Indonesian lawyers, you see Malaysian lawyers everywhere. You see Singapore lawyers everywhere. We are in London, we are in New York, everywhere, okay? First, the language. And for example, to get into university, NUS, for example, National University, there are probably 3,000 students will ask to be placed in the university. Okay, you have to sit for the exam for that. And all of them would have 4 A's, straight A's with A star, all that. Okay, you have to go for interview, and most probably about 300 or 400 of them will be accepted. And these are 1% of the population. What we're talking about, really brilliant student. So basically, because of the value of because, all right, this, English is very good and they are clever than most. Okay, that's why, all right, they are accepted everywhere. In Malaysia, during my time, okay, because I entered university in 1980, surprise, I'm very old. Okay, we were everywhere because English was very much used, all that. But right now, in 2012, Singapore does not accept MU students anymore, because I think we've lost the ability to speak English very well. Okay, at one point of time, all right, I could go and practice in Singapore. I could practice in UK, in Hong Kong, easily acceptable. I have got so many colleagues all over the world. So you have to be a bit more international if you want to go international. In Allen and Gladhill, for example, we have 500 lawyers, and most probably about 100 are Malaysians like me. We have tried to get Indonesian lawyers to come in, all right, because of all the arbitration lawyers, in SIAC, okay, we don't really get to see Indonesian lawyers coming in, very. So, our joint venture partner, or our partner in Indonesia is SNT. And this is something that we're trying to do, look for an Indonesian enterprising, aggressive Indonesian lawyers that are willing to go and do this arbitration, international arbitration, and go to international arena. Until today, we're still waiting. No traction. So basically, it's unfair as well to actually blame the Indonesian government if the Indonesian lawyers themselves are not that interested. Okay, now it's a bit difficult to go to Singapore because of the work permit, even before COVID-19. We're willing to bring the lawyers to Malaysian firm, but no traction.
Okay.
Because basically the interest is not really there.
Thank you, Amina Kasim.
It's very long-winded, but I hope it is worth going, except if you go to Indonesia.
Thank you very much. I don't know against the Indonesian health law, law of health, not because this time our for have lunch. Before that, I have you 1 minute last statement from you, Professor Hartini Saripan. This 1 minute statement from you to closing this conference.
Okay, Dr. Imam, thank you so much. I think I've said everything during my session just now. Once again, it gives me great pleasure to be here, and thank you so much for inviting me. And I really hope that we can meet again. And I welcome colleagues from Indonesia to UITM Shah Alam. And I think we can have so many collaborations between Fakultas Hukum in UPNV and Faculty of Law UITM. Thank you so much for inviting me. Thank you.
You're welcome. You're welcome, Professor Hartini Saripan. And the next 1 minute from Professor Imahanto Juwana.
Well, thank you very much, Dr. Imam. I think we learned a lot from this conference, from this webinar. And I hope that from what we learned, that we will have motivation to not only pass our Faculty of Law and then work in Indonesia, but also work outside Indonesia. My experience, unfortunately, my experience is not as a lawyer, but as an expert on Indonesian law. I've been asked to appear before various arbitration around the globe, and the payment is very encouraging. And so I would like to ask all of you from Indonesia to consider of working around the arbitration, because this is something that is very challenging, but again, the benefit is there. So I hope with this webinar, we can learn a lot. Thank you very much.
You're welcome, Professor Rimanto Juwana from Rector University of Ahmad Yani, General Ahmad Yani. The next, last, Kamila Kasim, 1 minute closing statement from you.
I'm not very sure of how many participants. Mostly
400 lah.
500.
Yeah.
But mine is not really for students, all right, because you have professors, talking to you. I'm talking more in-house counsel.
Yes.
Yeah, I'm more in-house counsel. If you want to go for arbitration, please understand what is arbitration for and how to use it. Okay. And if you want, because Pak Imam and I used to do a lot of arbitration seminar together with, because my ex-partner now is the Chief Justice of Singapore, Mr. Sundaraj Menon. Yes, he's a number one, Singapore lawyer. When he was practicing, he's probably, top 50 in the entire world, and we don't even know where he is. So we used to do arbitration, and I'm more than happy, to do this sort of webinar together with my colleague, to give more talk on understanding arbitration and how you use arbitration in that sense. Okay, so that it will be more useful, and then lawyers like us, we are very creative. We can delay things if the language is not clear.
Thank you very much. Thank you very much, Kamila Kasim. And to closing for this conference, I think respect our Dean, Dr. Abdul Halim, but I give the time now from me. I think thank you very much for your participants' attention, and for all of the speakers. Thank you very much, Professor Hatini Saripan, Professor Rimanto Juwana, and Kamila Kasim. And next time I'll give you to Miss Kayla, the MC, to close the statement from our Dean. Please, Kamila.
Thank you very much.
Kayla, thank you. Welcome. Bye-bye.
Yes, thank you. Thank you, everyone. Thank you to all the speakers for the informative insights, and hopefully all of the information given can enlighten us with new perspective. Also, thank you to Dr. Imam Haryanto for running the main agenda successfully. Ladies and gentlemen, we have reached the end of our session. We would like to welcome Dean of Faculty of Law, Universitas Pembangunan Nasional Veteran Jakarta, Dr. Haji Abdul Halim, to deliver the closing speech. The time is yours.
Tarikan.
Kepada Bapak Abdul Halim, dipersilahkan.
Baik. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Good afternoon. Salam sejahtera buat kita semua. Honorable guests, keynote speaker and panelists, ladies and gentlemen, participants of the conference. I hope we are all in good health and attend this conference today. On behalf of the Faculty of Law, Universitas Pembangunan Nasional, Veteran Jakarta, I would like to thanks to Ibu Rektor, UPN Veteran Jakarta, Bapak Yang Mulia Dr. Haji Syarifuddin Esa MH, Chief Justice Supreme Court of the Republic of Indonesia, as a speaker in this conference. And also, I also express my appreciation to panelists. First, Associate Professor Hartini Sarifan, Dean of Faculty of Law, University Teknologi Mara, UTM Malaysia. Also, Professor Hikmah Hanto Yono Esa MH, Rector of University General Ahmad Yani. Kamila Kasim, LLB, LLM, lawyer of Allianz from Singapore. And also my friend, Professor Ariana Kisa from Washington University, USA. And Norris Yang, ADR International Limited, Yang Chan from Hong Kong. And also thanks to Mr. Dr. Imam Haryanto as a moderator in this session. And all participants, we will present and full support for this success of this conference. Ladies and gentlemen, it is a great pleasure for us to host this first international conference on law studies organized by Faculty of Law, Universitas Pembangunan Nasional Jakarta. This is our first INCOLS, which we took as a theme is law and policy on transnational issues. This theme was chosen in order to respond to several transnational challenges on various perspectives such as law, education, society, humanity, economy, and etc. In addition, on this global pandemic, transnational challenges and collaboration are always being an interesting topic to discuss. To develop a research network and other collaboration in the field of law, we hope this event will take place every year. We really hope this conference would strengthen and continue our relationship to cooperate and collaborate with our partner in matter of teaching, research, community service, especially on the law studies. Last but not least, we hope try to our best to make this conference perfect for all of you, but we realize that nothing is perfect. Therefore, we, as Edin has said, we apologize if there should be an inconvenience you may feel during the conference. Finally, I would like to thank all of you who participated in this event. Thank you very much, and see you the next conference. And Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Dr. Haji Abdul Halim, for the time. And with that, we would like to say thank you to every speaker, moderator, and all of the audience who have participated at this conference from beginning to the end. We hope that this conference successfully gives positive and informative insights to be applied in everyday life as well. I represent all of the committee on duty, would like to apologize for the wrong words and deeds. Finally, there will be a panel presentation by the presenters later at 1:30 p.m. Western Indonesian time. So for all the presenters, should stay tuned for the panel later. Once again, thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Pak Dekan nggak ada foto bersama. Kayla, foto bersama nggak ada. Sudah ya? Oke. Thank you very much for everyone. Kamila Kasim, see you again soon.
Okay.
Have a
Thank
nice
you
day.
so much.
Ya.
See you.
Sartini
Bye.
Sarifan,
Thank
very
you,
much.
Dr. Imam.
Sama-sama.
Thank
Thank you,
Pak
Dr.
Imam. Thank you very
Halim.
much, everyone.
Yeah.
Ya.
Bye.
Terima
Nice
kasih.
meeting you, Madam Kamila.
Kamila yang
Thank you.
keren.
Yeah, thank you, Professor. I wish I knew
Yeah.
the participants, because I'm doing a favor, Pak Imam, because I think I spoke to Pak Imam yesterday.
Yeah, but it was very useful.
Okay.
Yeah, perhaps you can come to the faculty one day. For the webinar.
I have offered myself so many times. Professor, I think your Siti Hajar was
Yes.
my classmate. Or sorry, those in Indonesia. So Wati. I have told them anytime, Nomawati, and I
She
think
told me.
a few lawyers,
So we'll be in
from
contact very soon.
Yes.
Madam, bye. Take
Thank
care.
you very much, Professor. Thank you.
Thank you so much.
Have a nice day.
Bye.
Bye-bye. Have a nice
Please
day. Thank
be
you very
safe.
much.
Be safe, and and observe social distancing. Thank you.
Yes, you're welcome. Thank you very much, Kamila Kasim, Professor Ratini Sarifan, my dean, Bapak Abdul Halim, Dr. Abdul Halim. Thank you very much. See you again soon.
Tania
Bye-bye.
Bapak Abdul Halim, Tania ya,
Tania,
dan
Tania
seluruh
tuh.
pasukan di UPNV. Okay, bye
Okay.
Dr. Imam.
Yes,
We
sama-sama.
will be in contact very soon for the collaboration ya.
Thank you. I'll do.
Bye.
My rector also give regards to you. My rector, Ibu Erna. Yeah.
Oh
Ibu
yeah,
Erna.
Ibu Erna. Okay.
Yeah, say regards
Thank
to
you so
ya.
much, Prof. Thank you for inviting me. Bye.
Bye-bye.
Stay
Have a nice day.
safe.
Bye-bye. Assalamualaikum. Bye-bye.
Waalaikumsalam.